drive through that area, you will understand, okay, this is backward. But I did not do that. I said, I will go after this, I will grow. When you sit in an auditorium, if the front seats are vacant, that is an insult to the speaker. That's why you have to occupy seats from the front. And when you enter this row, you should not sit here first. You should go to the last, so that people who come later can sit here. If there is a passage on either side, you should go to the middle and sit there, so that people who come from either side can. There is a right, there is a rhythm in everything a professional does. Okay? Now onwards, whether you like it or not, do it. Whenever you go and sit in any auditorium, occupy the seats right from the beginning. Okay? Otherwise, don't go to the auditorium. One. And second, a person who comes to the auditorium late has no right to ask questions. Because you don't know what has transpired before you enter the auditorium. What is the implication? Implication is you are not supposed to go late to any program which is scheduled, unless it is so important. If I am sitting here as the chairperson of the session and you raise your hand, I will say, gentlemen, you have entered late. You have no business to ask questions. Shut up. That's how the chairperson will be. If he is also equally trained. How to get into a car? When somebody brings his car, when you open the door, how you enter the car, lot of experts there. And if you go to top of the forms, best of the forms, you should not become a hard man also. You should be totally professional. That has got nothing to do with it. See, why we have to tell this is, as the Honorable Police Officer has already told you, there are new crimes added. One of the new crimes that is added is organized crime. What crime? What word? First word? Organized. See, when criminals are organized, why law students should not have? Right? Why they are called organized crimes? Why they form a crime syndicate? In universities we will have syndicates, but in criminal world also they have syndicates. What is the essence that is required of these criminals to qualify themselves to be organized criminals and form a crime syndicate? If you study deeply about organized crimes, you will come to know that they have values and ethics far superior compared to the police. That's how they are one step ahead of the police personnel when it comes to the fight of perpetration of crime. And now it is a challenge for the police forces to match them, operate, bring them to book. If not, that's you. And one thing I tell you, you are all going to be professionals, and there is a greater responsibility as professionals than ordinary people in the society. If you go back, in one of the books, Ivan has written in a very beautiful manner, society has always looked at professionals whenever it is in crossroads. Now we are in crossroads with new criminals. And they will wait and see what lawyers will do. And they follow them. Because they know that advocates, lawyers, they are the people of judgment. Because they have intellectual abilities. Judgment is one of the requirements of 7 years of advocacy that you will be studying in your 10 of 5 or 9 of 5, whatever language you use and the subject. Okay? So, when the country is passing through a phase, people look at what lawyers do and they follow it. For that reason, first we have to understand this legislation. And if you want to enter the rest of the forms, you should be in a position to ransack a judgment of 400, 500 pages, overnight and write a summary, case brief of what is decided in that case. And the moment it is started pronouncing in the Supreme Court, you should be in a position to track that and form your own opinion. That is the speed with which we have to move, especially when it comes to the point of criminal. I am not going to tell you about what is there in different section of this act, this act, this act. That's not the purpose. Why crimes? See, Supreme Court decriminalized 377. Okay. And legislature decriminalized attempt commission. Supreme Court decriminalized adultery. What is a crime? What is a crime in the creation of people who are in authority? Legislature can criminalize and decriminalize activity. It can make an activity which is not a crime into a crime. If it is already a crime, it can decriminalize that and permit it. That is possible with the legislature. And judiciary also has done that by crashing down whatever the legislature has done. See, when we speak of these things, I always appeal to the students to read the original books. If you have studied criminal law, why not? The Indian Penal Code, Criminal Law 1, and if you have missed reading those 5 chapters which are prescribed from outlines of criminal law by Kenny, you have missed it. There is a purpose with which these things are prescribed, and nowadays people are not reading, but I insist you read all the basic prescribed things. So in the first chapter there, one wonderful expression comes. Crimes originate in the policy of the government of the moment. Where from the crimes come? Crimes originate in the policy of the government of the moment. Depending upon the time frame through which the society is passing through, different activities will get criminalized, and simultaneously some of other activities will get decriminalized. Crimes are in the policy of the government, which is what is our activity, what is to be criminalized and what is not to be criminalized. It all depends upon the national policy, where the society was passing through industrial revolution. Laissez-faire, there were different things. Once this laissez-faire era is over, the whole thing is mechanized, industrialized, and welfare constitutions, controlling constitutions come into existence. Second of those crimes were decriminalized and new crimes were created. So if crimes are created, if new crimes are added to Bharatiya Nyaya Samhita, it is because of the requirement of the contemporary times. If certain of the crimes are decriminalized, that is also incurable. You see, adultery. Living in relationship is recognized. And living in relation is a crazy relation. You have right to live, you can live anywhere, with anybody, live in relation. Domestic violence act applies to living relations, yes, it applies. Maintenance for children born out of living relations, they 10 years back in Bangalore, you have a child, yes. Are you married? No. Are you a single mother? No. My English came to an end. Where girl just walk to ask her, do not move, and she is not telling what she understood that this fellow is limited in his language. She felt he will educate me. I am in an open relationship. If she had not told it, I would have been better. Now this open relation is thrown into my head, and I have to go and whom to ask. All my friends are like me only. I went after that, I said I will understand what is this open relationship. I understood. The distance is society, Indian society, where is the place for her right? No, freedom. See, we are becoming liberty. Okay. So, according to the thought process, the activity are getting decriminalized. Liberty is very, very important. Freedom is very, very important. And it is not worth living in a country where freedom is not there. When we were studying in Mysore University, Nirmala Madam also was there. She was my classmate. One Russian had come there to study. I tell you, he was enjoying. He will walk like that. And shirt of different colors, flowers, all the colors. And he will dress himself, chitra, and roam around in the air. We will think he was in a position to speak some broken English. In his country, it was compulsory to wear green uniform through life. Always that uniform of the state. State has decided that all of them will put up that green carpet and right from the birth that fellow is with that color and he has so much of awareness to the very young India he became colorfully violent. And fellow will smoke bees and all this. That is freedom. A person who comes from Russia understands what is freedom. What is to live in a libertarian state? I tell you, we are all blessed to be in this country under this constitution which is given to us by those great forefathers. I am a specialization in constitutional law. Try teaching constitutional law to students like you. Retired also. After retirement, one of my former students came and presented me about you must know your constitution by Parliament. And I said, okay, at least after retirement I should know my constitution. Right? You must know your constitution. The other is Palinarian. And if you are not reading this book, Palinarians, you must know constitution. You will definitely miss something. It's published to the last year, just few months before the demise of Palinarian. The great advocate India says Palinarian is not an ordinary person. And for your information, I have read all the books of Palinarian. If I like somebody, I will read all the books that I have done by that person. You should ransack the library. By reading some all the tissue papers, you cannot become a professional. You can become a sort of agent, a sort of cow, not a professional. So you must know your constitution. This is a highly libertarian constitution. Why libertarian constitution? Because liberty is organized in the constitution which cannot be touched by any political party with any group majority. Because liberty is there, due process is guaranteed under this constitution. And when you speak of criminal laws, CRPC enables we speak of process, procedure. Okay? Ways and means by which crimes will be investigated, prosecution will be conducted, and people will be punished and sent to prison. Criminalizing a sort of restriction on the liberty of the individuals because unrestrained liberty is very dangerous to liberty itself. Where is threat to liberty? Threat to liberty is liberty not being controlled. So, in the interest of liberty, see, I am speaking, you are keeping good. You know, what is the limitation of your freedom of speech? My freedom of speech is limitation on your freedom of speech. That somebody raises that his freedom of speech will become a limitation on my freedom of speech. So, liberty is restricted in the interest of liberty itself. When we behave accordingly, all of us will have liberty. And if you very, very little. All law is about order. And there will be order in this society where the power is restricted. To restrict the power, rights are there. To restrict the behavior of the individuals, rights are created in the society. This is the equation that is there. Okay. So, where this criminal procedure is there, Bharatiya Nagariga Suraksha Samhita, Bharatiya Saksha Adhiniyama, earlier Evidence Act and CRP, towards what these things are designed. If you take over the what is it, Justice Malibat Committee report, what is it, reforms in criminal. First page, it is very clear, quest for truth. In this whole due process, when somebody is prosecuted, Anglo-Saxon system believes him to be innocent. That wherever he is presumed to be innocent till he is proved guilty beyond reasonable doubt. That is the standard required. Beyond reasonable doubt is the standard required. Applying that standard, it will be decided whether a person is guilty or not. Till then, he is presumed to be innocent. Why it is determined like this? Why it is framed like this? Because there is a belief, there is a basic principle that is coupled with this presumption of innocence. That is, let 1,000 criminals go uncaught. Let 1,000 criminals escape. Not even a single individual who is innocent should be convicted. This is the law. Let any number of criminals escape. Innocent should not be punished. The question arises whether this is a good principle. When you start reading this by the arguments, you must know your constitution. At the beginning only he makes. You see, you have provisions about reservation here in this constitution. And you have worked in 70 years, you have experimented with reservations in educational institutions, in public affairs. At least at the end of 70 years, please consider whether this is serving any cause, whether it can be an instrument of development, whether it can really help those downtrodden, economically backward, whatever, whomever you want to support. You have built a huge jurisprudence. And ultimately now we have arrived at such a situation with people who are sitting in admission committee, horizontal reservation, vertical reservation, which seat is to be given to who. I tell you, it is such a chaos. When I am talking about reservation, if I make mistakes, I will come to know that I am barking something which is not right. Nobody will come to know that what I am speaking is not. Because nobody knows what it is. It has become a sort of general. So why is unnecessary? Please reconsider whether it works. Same thing happened here also in criminal. You have done it for a period of time. Reconsider whether it is aiding anything else. See, you have to remember why crimes are committed. Why crimes are committed? Come on. Why people commit crimes? Come on. They want something more. They are not satisfied with what they have. You see, it is like this. I want to be thorough. Huh? Without money. I can earn money. No, there is no private. If I am not happy, you can do nothing wrong in it. That is how illegal is bad. You should not do it in unlawful. That is right. Right? So, what this fellow does is, if I want to earn, I have to work like this for so many years, then I will get only this money. If I break this law of this fellow, listen, take care of your health. under old APC universal. So what this goes is it is an easy way of earning lakhs of rupees. No. So you will become a contract cleaner. Supari. Supari is murder, 50 lakhs. So you want to become a crorepati, two murders you will become a crore. Right? And how to do it? I am 62 years, I could not do it. I have taken services of a boy who is now 16 years, 15 years. Because he will be released, no? He is not an adult. Oh, that. Getting wealth and is after, that's what that is good. Not that other is yours to criminals. He who commit crimes, one for motive. If it is a murder for motive, it will happen. I tell you that, whatever the criminal law, whatever the criminal procedure, whatever the criminal, we will do that. Because there is a motive. And another crimes for below benefits. When violation of law is advantageous, then nobody has to law people violate us. This is simple. When it comes to the point of economic crimes, this is what they have. That's why certain of the activities are being criminal. And when it comes to the point of crimes like terrorism, organized crimes, the place where it is visiting Vishwasaraya Tower in Bangalore, Dr. Revaya Advisor, there was very day, hundreds and hundreds of women come there with children, with the river box, with lunch box. They are filling some applications, what applications, some banks have disappeared. Financial fraud has taken. Now by filling that application, they will get 1 lakh rupees or something like that. And it is months and months people come there, how many lakhs? These are all economic crimes. And all our money, hard-earned money which we have deposited in the banks, it has gone because somebody released loan to somebody and something happened and ultimately all these middle class, lower middle class men and women, they are suffering. See, what happens is, a murder affects one family, one person, but an economic crime will affect the whole country. These are very, very dangerous crimes that you have been one joke appeared, not joke, argue in the newspaper 3 years back. Father is sitting there reading newspaper, son is sitting there doing something. Father asked the son, what you have decided? Then son replied, I have decided in terms of a career in organized crimes. Then the father asked, governmental or non-governmental? No, governmental organized non-governmental, those figures that what Justice Santosh said, astronomical. We do not know how many zeros are there in a crore. And people speak in terms of 20,000 crore, 1 lakh crore. We don't know what is it. I am not good at talking, that's why I do not want to give that one. Which I cannot know. Whatever what I can have to the control of this number. There are greater threats. Terrorism, espionage, organized crimes. For that reason, you require stringent laws. If you study about organized crime, there is a WAS, VOWS WAS. And below the WAS, you have handlers, you have handlers. And below them, you have operators. So organized, so systematic. One robber blind into a organized syndicate breaks open into a bedroom where the lady is sleeping. That lady gets started, don't rape me, don't rape me. I am a professional. I have come here to see you are dead. That is the organized criminal. He knows what to do, what not to do. He will not run into problems. An organized criminal who is hired to kill will kill and get out. He will not do any nonsense. Because there is every probability that he will be running the risk. They are totally different. They have their ethics. They have stringent punishment for violations they will eliminate. And they are a common enemy in law enforcement authority. ED, CBI, state police, income tax, they will not act in a coordinated manner when tackling a criminal. But criminals, murderers, drug peddlers, sex workers, gun runners, all of them work in a coordinated manner. That is the difference. The discipline they have, these people cannot do. That's why we need some laws, very stringent laws. Stringent laws are necessary. There is a great statement of Benjamin Franklin. Those willing to give up little liberty for little security will neither have liberty nor security. We speak, we say, we are in the UN trade, when caste census comes. All of us will stand up to the caste census. No, this is not this. Freedom of expression. Freedom of expression is there within this country, India is. After the explosion of twin towers in America, till now there is no terrorist attack. And what is happening in this country? Every day is a development. Some last year, some shooting there, something here, something. What is happening? After that event, in America, they brought in one legislation known as Patriot Act. Popularly known as Patriot Act. A terrorist is declared to be enemy of the nation. And once a person is declared to be enemy of the nation, he can be shot dead straight. Yesterday, day before, we were reading something that some of the accused people were given cigarette, biryani, etc., etc., and we were going to terrorist house. And our courts opened the doors in the midnight, went up to 4, 5 in the morning as to whether this person was caught on camera shooting people indiscriminately, whether this fellow is to be hanged or not. Right? We are all witnesses to that. This is due process. What is due process of law? Garland accused. Our prayers, please, my Lord, let me know if you have committed this crime. This will not work. Right? Stringent laws are necessary to tackle such. There should be the deterrent element. There should be the channelizing aspect of law, which will scare people from committing such things. If we are not ready to run this risk, we will run into problems. Because the type of crimes that are coming to existence are not affecting one individual, they are affecting the whole state. Lot of people will be affected. That's why it changes. Who is the terrorist? Terrorist has no enemies. He kills people, no. Whether he has any animosity with all these people, no. The business is to kill. It is a machine. The terrorist is a machine. Okay, that's why our honorable justice B.S. Mayawat was always saying, a terrorist has no human rights because he has no respect for human rights of nobody. A terrorist should not be given. Emotionally, he was saying like that. But we are in a country of due process of law. We will prosecute him according to law and hang him whenever necessary. There should be discrete balance between the process that is provided and the behavior that is expected of the people. There is a wonderful saying, certain laws are seldom obeyed, stringent laws are seldom enforced. ಸೂಕ್ಷ್ಮವಾಗಿರ ಕಾನೂನಿಗೆ ಮಾನ್ಯತೆ ಸಿಗಲಿಲ್ಲ, ಕಠಿಣವಾದ ಕಾನೂನನ್ನು ಯಾರು ಜಾರಿ who's treated as active people continue unaware. And if you make very simple laws, people will not smoking in public places is prohibited. Right? But you see people smoking in public, what happens if you are maybe that small corporation or whatever, the current 3 days, whatever, I have 100 rupees or whatever. Right? If I can pay 20 rupees for a cigarette, I never mind anyway my papa's money now. Right? So we will not respect this law, rights of smoking in public place because the consequences are very many. We will not respect. But stringent laws of every prohibition. Some of you are going to marry probably unless you are going to exercise your freedom that is created out of so many judgments of the Supreme Court. Okay? Then you will see what the would-be groom will be, whether he believes in these laws or whether he is also a traditional groom where you are waving in gold and whatever. So dowry prohibition, judges' families are there, police officers' families are there, politicians' families are there. No, this is not dowry, it is a gift that we are giving to our children. I want my daughter to be happy. Rational in you. See, the problem is, laws should be discreet. Then only there will be respect for them. Otherwise, people will not respect. So, what happens is, there will be change in the jurisprudence of criminal. One small equation I will give. Let 1,000 criminals go escape. Not even a single individual innocent person should be convicted. This is one equation. What happens? In the interest of protecting this single individual, we are putting a procedural law of procedure and evidence, wherein we are providing an escape route to 1,000 accused people. Now we will change the equation slightly. Can we run a risk of convicting an innocent and take a chance of convicting 1,000 people? If we are the formula, then we will convict 1,000 people, and there is a possibility that one innocent also will be convicted. Which is better? Whether allowing 1,000, forget 1,000, take 100. Whether allowing 99 criminals to escape is dangerous to society, or whether convicting one innocent person is dangerous to society. Convicting one innocent is dangerous to society, or allowing 99 to go back to society, criminals. Which is dangerous? Convicting one, no. That's it. So when we make stringent laws, always there is a possibility that sometimes university said somebody, we want to install cameras in your college. How many cameras you want? I said one. Where you want this to be fixed? Fix it to the principal and keep the display in the college and let the children know what principal is doing sitting in the chambers. Good, no? That way principal will be safe because there is a camera, there will be no allegations against the principal. Those interns, boys, girls, against the judges, all these things come, no. That is the thing. So we have to run with this. So what we do is, we change the form. Everyone is to be presumed to be innocent till proved guilty. Now we have created rights wherein we presume to be, presume this person to be guilty till he proves himself to be innocent. So presumption of guilt. Second of the special right, there will be presumption of guilt. Vicarious criminal liability comes into place. Companies will be held responsible. The property will be forfeited, confiscated, all the things. Why people are going acquitted? People are acquitted because investigation is a fail. Prosecution is a fail. So they change the jurisprudence. Shift the burden of proof deterrent punishment. Really, the police officer told for how many crimes there is minimum punishment. When there is minimum punishment, judge has no discretion. If he convicts, he has to give the minimum mandatory punishment in the day. High fines and variable confiscation of goods, denial of benefit of probation, summary trials, presumptions, cognizable offences, non-variable offences, constituting special rules. So variable new things will come into existence. There is a wonderful statement of that Jeremy Bentham. I will read it out for you. Every precaution which is not absolutely necessary for the protection of innocence affords a dangerous lurking place to crime. What methods of procedure can be more dangerous than those which put justice in opposition to itself and which establish a kind of incompatibility with what we are doing? Why this procedure? If we are not going to conduct various culprit, that is the question which Jeremy Bentham asked. So, when we move towards this, when you look into the parliamentary debates when these three bills were introduced in the parliament, Honorable Home Minister made a statement that they want to enhance the rate of conviction. They want to go up to 90%. 90% of the accused should be punished. Why 90%? 100. It will be if they are years to this. Because they should not be. There is a wonderful statement described by the recusals of Justice Department in America. Look at the way we approach things. The United States wins its case whenever justice is done to one of its citizens in the court. United States wins its case whenever justice is done to one of its citizens. Conviction is not the goal. Justice should be done. And the procedural framework that is evolved should have such a discrete balance between liberty and regulation. Over anxious, we should not destroy liberty in the anxiety of preventing certain of the crimes. And at the same time, we should not allow an unbridled choice to the liberty to run amok unnecessarily and create problems. So when new criminal laws are brought into existence, there are so many things which have to be, say, clarified, amended, as Honorable Justice was telling in the morning. We have to, as we have built the jurisprudence and the Constitution, and all the old criminal laws, now new interpretations, new jurisprudence, new glossary will come into existence. We have to wait and watch. But in the meantime, there are certain of the things which are a sort of aberrations in this rule. How many of you have paid spot fine for violation of traffic regulations? I have paid once. Vinita has paid. Sureka has paid. Gentleman in black coat has paid. Okay, good. We are all enriched human beings. How many of you have read what was printed on that page? You have read? What is that? No, for not wearing your helmet, you were penalized. You paid that money and that fellow gave a paper. Whether you have read that paper? No, fine you have given, but he gave a paper, no. What type of law student you are? Today you go and violate some traffic rule somewhere. Or stand there till somebody else violates. Because you Muslim parent ಮಾಡಲ್ಲ ಅವರು ಡಿಸ್ಕೌಂಟ್ ಹೋದಲ್ಲ ಹೇಳಿ ಅಂತ ಕೂತ್ಕೊಳ್ತೇವೆ. See, on that, what is written is you have violated this rule, maybe riding without helmet, overspeeding, without switching on the light, whatever, for which you are penalized 200 rupees. You can accept this and pay. If you do not want to pay, this is a challenge, you come and appear before the court. That is the paper. Okay? If you accept to pay, it becomes a judgment. This paper is a judgment. If you do not want to pay, this becomes a challenge. You will go to the court. Different formula. Criminal justice system is a very wonderful system. So on this spot judgment you will get it 50. Different formulae will be tried in the criminal process for speedy disposal, for effective investigation, for variety of things. See, you have heard of community service being introduced as a punishment. Community service. I will just give you one point and give that. What is the time now, madam? 3. One LLB fellow drank water in a court and ran into problem. You have heard of this? Happily he opened the bottle and that's what he got. Okay. So this is a bad judge. He also has a watch, but he will not look at that. This punishment, community service, for trivial offences, including defamation, for small petty theft and all. The magistrate will order, you have to go and work in the library of VBCL for 1 month. For that there is no remuneration. So that's why LLB fellow who is put to community service has to come to VBCL library, sit there in the counter, issue books, take returning of the books, cancel entries and all that. 1 month he has done and he has served that sentence. That is community service. And there is a guitarist and he has to go stand in the park and play guitar every evening for the public entertainment. That is the community service. Like, afterwards, he has to apply for a job. In that application, there is a column where you convicted for any offense. This fellow is convicted. He is given community service as a sentence. Right? He has to say yes. If he writes yes, he will get disqualified. There is what is known as expiative punishment. Expiative punishment. Once you serve that punishment, you are free of guilt, free of contempt, free of stigma. If it is expiative punishment, when you convicted for any offense, boldly you can write no. That is expiative. Such wonderful things are there invented by mankind. Seasoned people, if they sit in the law reforms committees, they can definitely come out with qualitative legislation. This is a change that is taking place in our time, and those who have completed their criminal law, you have to read one more criminal law without marks, and there is no result also, no pass fail. But you have to study if you have completed. And those who are in those classes where they have not studied IPCC or IPC, they will be studying the new one, they will be better off. But you cannot represent the old cases which have already taken place. So that is the point that you are going to enter upon. That is to see fresh mind, nothing like a fresh mind. Fresh mind thinks in a wonderful manner. When this smoking in public place, one student came to me, sir, I have found an interpretation, sir. About what? About prohibition of smoking in public place, sir. So what is that? Sir, public place definition is like this, this is this, this is this, this is. What is your interpretation? So my interpretation is, if you are walking while smoking, you are not violating this. What is smoking in a public place? You should not stand in a place and smoke. you keep on changing the place. So wonderful equation, no? If you are walking while smoking, you are not smoking in public place. One those physics fellows are there. At a given point of time, the body is time and space, no? So he is static. He is smoking in a place every moment. You are able to. But at the same time, I appreciate that he has applied his mind. No? Innovative. So as youngsters, you should keep on thinking about new things, learn new things. It is the quality of the thought that matters, not the numbers. So read these new provisions, and if you feel some improvement is possible, necessary, read to the concerned authorities as the honorable judge was. Whenever a judgment is given, whenever a new law is enacted, be the first person to read it. Okay? Even if you read after a month, you will be the first person because nobody reads. Okay? All the best. Thank you very much.
Conviction is not the goal. Justice should be done. That is what the crux of this passing of the legislation is concerned, wherein sir has given insightful, educative, and intellectual speech, and wherein we have learned so many things from sir. Sir, thank you so much for a wonderful session, sir. Bottom of my heart, I thank you, sir. Thank you so much for this. Moving on to paper presentation session, sir, I request you to stay back for the same. I request Navin sir to take over the session.
Good afternoon, all. I, Dr. C.B. Navin Chandra, Assistant Professor, Vaikunta Padilla College of Law, Udupi. Welcome you all to KILPAR sponsor one-day national seminar on the changes and adaptations in the new criminal major acts and their projected impact on the criminal justice administration system in India. We are moving to paper presentations. In this session, we are fortunate to have Professor Dr. C.S. Patil sir, Research Head, KILPAR, Bangalore, as chairperson of this session, and Professor Dr. Venugopal sir, Professor of Law, SDM Law College, co-chair of this session. On behalf of all of us present here, I welcome you, sir, and welcome all the paper presenters and faculties and students. In this session, we have 16 papers. I will call upon code number of each paper presenter according to program schedule already given to you. Each participant can take 5 plus 1. After 5 minutes, there will be reminder and they can take 1 more minute. Let us commence the paper presentation. First, I call upon Ms. Tushar Ullas, Assistant Professor, Sri Narayana Guru College of Legal Studies, Kollam, Kerala. Madam is present on the topic Community Service as a Punishment, a vehicle offline of hope to prevent sentence in policy in India. Over to you. Ms. Tushar Ullas.
Good afternoon. I am Tushara Vilas, working as Assistant Professor at Sri Narayana Guru College of Legal Studies, Kollam, Kerala. My topic for presentation is Community Service as a Punishment, a beacon of hope to prevent sentencing policy in India. Let me start my presentation. The backbone of every civilized society is Indian criminal justice system. As far as the criminal justice system of India is concerned, it is having the backdrop of British colonial period. As far as the Indian criminal justice system is concerned, which consists of IPC, CRPC, and evidence. Of these IPC and Indian Evidence Act, which are the products of colonial period, and CRPC is also more than 50 years of period. So it is necessary to revamp this existing criminal justice system in India. So with this object, the new criminal law bill, that is Bharatiya Nyaya Sanhita Bill, Bharatiya Nagarik Suraksha Sanhita Bill, and Bharatiya Sakshya Adhiniyam Bill were introduced in the Lok Sabha on 11th August 2023. And these bills were sent for the recommendation of the Parliamentary Standing Committee for Home Affairs, and along with the recommendation of the committee, these bills were reintroduced in the Parliament. And these bills received the assent of the President on 25th December 2023. And according to the notification issued by the Ministry of Home Affairs, these new laws will come into operation from 1st July 2024. So, one of the major changes in the criminal justice system is that Indian Penal Code 1860 has been replaced by Bharatiya Nyaya Sanhita. Now, the focal point of this statute is Nyaya or justice. In the earlier penal code, in the earlier statute, that is in Indian Penal Code, it was punishment. And one of the major changes introduced in the Bharatiya Nyaya Sanhita is that one more punishment has been introduced in the act, that is community service. And the aim of my paper is to trace the origin of community service, then examine the models of community service as a punishment under various legal jurisdictions, and to analyze the effectiveness of community service as a punishment. Then, moving to the object of punishment, there is no unanimous opinion regarding the object and purpose of punishment. So, there are various theories regarding the object of punishment. As we all know, they are deterrent theory, retributive theory, reformative theory, expiatory theory, and preventive theory. And moving to retributive theory, according to retributive theory, the object of punishment is retribution. We can put an end to the crime by punishing the offender. And as far as the retributive theory is concerned, it is based on the principle I for an eye, tooth for a tooth, limb for a limb. In the earlier period, the basis of criminal justice administration was retribution. And according to this theory aims to show that every crime disturbs the balance of the society, and that balance can be retained only by punishing the offender. Then preventive theory, according to preventive theory, the object of punishment is prevention of crime. We can prevent crimes by disabling the offender by committing further offences, by putting him behind the bar, or by imposing death penalty. We can put an end to the crime. And according to reformative theory, the object of punishment is reformation. Even though a person commits certain crimes under certain circumstances, he does not cease to be a criminal. The object of punishment should be reformation according to this theory. And so the exponents of this theory shows that during the period of incarceration, the convicted should be taught some kind of arts or tasks or something like that. Then only we can make him a good person, and only after incarceration he can be a good productive citizen to the community. And according to expiatory theory, the purpose of punishment is expiation. So moving to community service as a punishment under Bharatiya Nyaya Sanhita. According to section 53 of Indian Penal Code, which deals with five types of punishments, which includes death penalty, imprisonment for life, imprisonment for a specific period, which may be rigorous or simple, then forfeiture of property, and fine. Bharatiya Nyaya Sanhita, section 4 clause F, section 4 clause F of Bharatiya Nyaya Sanhita, which includes one more type of punishment, that is community service. The term community service has not been defined in BNS, but it has been defined under BLSS, Bharatiya Nagarik Suraksha Samhita. And community service is a punishment. Community service is a work that the court may assign to a convict as a form of punishment, which renders some benefit to the community, but for which the offender is not entitled to any remuneration. Under BLS, there are under certain circumstances, community service can be awarded as a punishment for 6 petty offences like public servant unlawfully engages in a crime under section 202, then non-appearance in response to a proclamation under section 84 of BLSS, then non-appearance, attempt to commit suicide, to compel or restrain the exercise of lawful power, and the fifth condition is that theft where the value of the property is less than 5,000 rupees, where the offender is committing the offense for the first time and he returns the value of the property, or he returns the value of the stolen property, or restores the possession of the stolen property, which is dealt under section 303 clause 2 of the Act. Then the next is misconduct in public by a drunken person, which is dealt under section 355. And the last offense is defamation, which is dealt under section 356 clause 2. So, according to section 8 clause 5 of Bharatiya Nyaya Samhita 2023, in default of payment of fine or in default of community service, the court may impose simple imprisonment, and the term for simple imprisonment which shall not exceed 2 months if the amount of fine does not exceed 5,000 rupees, for 4 months when the amount of fine does not exceed 10,000 rupees. And community service is based on the fundamental principle that accord the criminal and not the accused. Then I'm moving to the issues of incarceration. According to the statistics published by the National Crime Record Bureau, Ministry of Home Affairs, the total number of prisoners in Indian prisons are 436,026, and the total capacity of Indian prisons are 436,226, where the actual number of prisoners are more than 573,000. That means it is more than 131.4% of the actual occupancy rate. Then moving to the issues of incarceration, the main issues of incarceration are overcrowding in prisons, unhealthy living conditions, then inhuman treatment behind the bars, death in prison, shortage of staff, exposure to hardcore criminals, the rejection and condemnation of the society, etc. So, if we are moving to the background of introducing community service as a punishment in India, even before incorporating community service as a punishment under Bharatiya Nyaya Samhita 2023, several futile attempts have been made for incorporating community service as a punishment under Indian legal system. And the Indian Penal Code Amendment Bill 1978 provided that community sentence should be awarded for offences punishable with less than 3 hours, less than 3 years. And after that, in the year 2000, a 20-member panel was formed for examining the existing criminal justice system in India, which was headed by V.S. Nariman, and Nariman Committee also recommended for introducing community service as a punishment in India. And in the year 2007, the Madhav Menon Committee also suggested for incorporating community service as a punishment in India, but all these attempts were failed attempts, and we could incorporate this form of punishment as an alternative sentence only by the introduction of Bharatiya Nyaya Samhita 2023. And if we examine the existing legal systems where the efficiency of community service, if we take the case of US, where the community service, the duration of community service ranges from 100 hours to 500 hours, and there the probation officers will be appointed for examining and supervising community services. In England, it we take the case of England, where the community service ranges from 40 hours to 240 hours, and the results in England exceeded their operational capacity. So, for reducing the overflowing of research, they introduced community service. In Australia, the community service ranges from 150 to 300 hours, where community correction officers are appointed for supervising the performance of community service work, and offenders are required to complete the directions given by the community correction officers, and if they fail to comply with the directions of community correction officers, the Minister for Correctional Service can increase the term of punishment. Then advantages of community services. Advantage of community service. It solves the issue of overcrowding of prison. It avoids stigma that may be caused by incarceration. It possibly eliminates the long-term psychological effects of incarceration. Then human resources can be utilized in a productive manner. Then it helps the offenders to acquire new skills. So there are so many advantages of this community service. Then without moving to the disadvantages and concluding my session, and community service is effective. Community service is obviously an effective alternative to incarceration, but at the same time, there should be strict supervision for ensuring community service. There should be strict supervision for the performance, rotation, and the performance and rotation of community service. For this, a separate department which is different from the prison and judiciary is required. Anyway, if there is an effective supervision, community service is an efficient alternative to incarceration. Thank you.
Informative present. Next, I will paper from the student. So, participants, kindly note each participant can take 5 to 6 minutes. After 5 minutes, there will be remind they can take 1 to 2 minutes. First, I invite P1, the board number is P1, will present on the topic unspoken aggression, marital taboos persist in patriarchal society. Over to you.
Good afternoon, everyone. Good afternoon, everyone. Good afternoon, judges. So my topic is on marital pain. Marital pain actually refers that within marriage, when husband is sexual intercourse with the wife, it's considered as marital pain. So according to the IPC earlier colonial law which we had, there marital rape under section 375, there is an exception 2 which refers that marital sexual intercourse with wife under 15 years is not considered as rape, which is we found in our new Act DNS, Bharatiya Sanhita, which is 15 years to 18 years. So why we increase the age? Like if the person is not, if the wife is not undergoing 18 years, not undergoing 18 years, that we not consider, we consider it as rape. But if the wife is above 18 years, we are not considering as rape. And when other unmarried women are raped by someone, we are considering it as rape, and even if we are talking about the effects, there is a after marital rape, there is a psychological effects. People are get depressed, women are get depressed, and they are not just getting the justice. And within the marriage, some women are not even able to speak what actually going through there, because in the colonial perspective, marital is under marriage is actually considered that woman is the property of the husband. And even after changing the criminal law, we had a parliament had a chance to reduce that, to cancel the exception for clause, and as a that husband, if the husband is forcefully or under coercion or under any kind of unconsensual sex without the consent of the wife, we can remove that. Parliament had an opportunity, but they didn't remove that. Under the after the Nirbhaya case, Justice Verma Committee in 2013, they actually recommended to remove the marital rape exceptions, but the Parliamentary Standing Committee on Home Affairs rejected that recommendation and conclude that if marital rape were criminalized, then entire family system will be under duress. So, according to Parliament, that if we are removing that marital rape clause, the family system will be in stress. But what about that women who are unmarried in that marriage, and they are facing this problem and they don't even say it to anyone? When other women who are not married and raped by someone are actually getting justice, and these women who are actually married and not getting justice, and they're sexually active, or their rights are equally violated in their home and with their own husbands or family. Though we have seen these remedies around, according to that marital rape, that if a husband is sexually anything, sexual cruelty and anything in that, so we are according to Domestic Violence Act, we are getting the women are getting divorce or judicial separations, but the many are not punishable. So this exception clause actually violate the woman married woman, Article 14 and Article 21, which is Article 14 actually, we can, if we are comparison Article 14, married women are not getting the right, the same right are getting unmarried women. If the unmarried woman is raped by someone else, but the married woman in the similar manner, if she is raped by her husband or anyone raped by her husband, she is not getting that justice. And also it will be giving her trauma, that lifetime trauma. And the only that exception actually prefer that we are actually denying the justice to the married woman. Again, in 2016, the Indian Ministry for Women and Child Development argues that there could not be a law against marital rape because marriage is a sacrament, and due to factors such as poverty, illiteracy, and religious belief. So, according to the government, we are not actually exclude the marital rape clause, exception clause, because marriage is a sacrament. So, we are considering marriage as a sacrament. So, marriage should be a mutual love. It should be care, not should be a coercion about the sexual intercourse with in their marriage, in their own home. So, so if I, so as a conclusion and my recommendation also, India should criminalize marital rape, where almost globally 150 countries criminalize marital rape. And among them, Australia, Armenia, Austria, Azerbaijan, Belgium, etc. was there, even in Soviet Union also. So if we criminalize marital rape, the women who are married will be getting justice. The same way unmarried woman is getting justice. So yeah, this. Thank you.
Thank you, madam. Moving to the next paper presenter, P2. The code number is P2. Will present paper on the topic Unveiling the Human Rights Dimension of the Bharatiya Nagarika Suraksha Samhita and Analytical Review. Over to you.
Good afternoon to all of our present here. Myself Bhavani from Kelly Law College. Today I stand before you to present my
You are free to
present my paper on human rights implications on the Bharatiya Nagarik Suraksha Sanhita. So life, liberty, and dignity are fundamental to all are fundamental human rights to everyone, and it is enshrined in the Constitution and in international conventions of international covenant of civil and political rights, and even in Universal Declaration of Human Rights and European Convention on Human Rights, as it is very fundamental to everyone. This are to be addressed vigilantly so that justice shouldn't be provided to everyone at the expense of their freedom and dignity, as law presumes everyone innocent until proven guilty. Uh, Speaking about criminal law and human rights law, they're both. I can see it is common to protect the individuals in the society, but they are primarily different when speaking about the scope and focus, whereas human rights refers to the protection of freedom and dignity of every person universally. Bharatiya criminal law creates offenses and punishes individuals. So, addressing the human rights concerns in Bharatiya's in DNSS, I can say first thing I would like to address about is handcuffing. You can see in section 43 clause 3, 43 clause 3 speaks that a police officer can handcuff a person based on the nature and gravity of the offense committed, and if the person is an habitual offender and is trying to evade the offense, evade the arrest, or has committed any offense related to counterfeiting, murder, acid attack, and so on. But basically, if you refer to other sections, section 43 itself, arrest it mentions that no unnecessary restraint must be used, or uh, the first no unnecessary restraint must be used, and so on. Basically, what I'm trying to refer in this section is this section says that person should be handcuffed based so that he's a habitual offender, and yes, he is trying to avoid the offense rather than seeing at his behavior at the time of offense. If you look at the section 43 clause 1, it states that if the person tries to evade arrest, all necessary means to all necessary restraint can be utilized to constrain him or restrain him. But if you look at 43 clause 3, it mentions only about habitual offender and one is trying to update. It is a good provision which shows progressive element, but at the same time it is not considering the behavior of the person, how he is reacting at the time of the arrest. And if you look at the report number 247 of the Standing Committee, they speak that they also mention the same thing, that handcuffing a person will limit the right to life. And secondly, to amend and remove this economic offense, because it is of very it refers to very type of offenses. So economic offenses should be removed is what is their suggestion. And if you look at the same report, it has been agreed and recommended by the opposition. So even if you look at the cases like Prem Kumar Shukla versus the Delhi administration, it says that handcuffing a person is very inhuman and arbitrary. Next, moving on to other sections like seizure of property or attachment of property. Here it refers to even this section I don't even it is also I agree it is progressive in a sense. But if you look at Prevention of Money Laundering Act, even the section has been included where the seizure of property has been mentioned according to section 4 or section 5, where there has been a time limit given that the property can be property which are immovable property which has been attached should be within a time limit period of 180 days. But if you look at Bharatiya BNSS, it nowhere mentions the time limit. It is quite vague about the time limit or where the property which has been attached can be restrained till. And even if you compare this section to CRPC, it shows CRPC section 120 mentions immovable property cannot be restrained. So basically concluding within one minute, I would like to conclude saying that the judges should review the cases, look they have to consider it even in case of police detention or other circumstances. They have to make sure all the trial prisoners are treated. So lastly, I would like to conclude by saying it is important to create a society where justice, where which is where crime has been vigilantly addressed, but it is also important to address a society where justice is equitable to all. Thank you.
Thank you, madam. So moving to next paper presenter, P3. Code number P3 will present on the topic Individual Liberty versus District of Criminal Law in Bharatiya Nyaya Samhita 2023.
Good afternoon, everyone. I am Sushma from KLE Society's SA Manvi Law College, Gadag. My topic to presentation is individual liberty versus restraint of criminal law. Firstly, I am going to explain what is overall presentation includes. First, meaning of individual liberty and under the Constitution of India, how it we define and
Whether all of you who are presenting papers are told that you are not supposed to reveal your identity. Is there part of the rule? All of you know that? Otherwise, put it up. You reveal the identity. We don't want your name and your institute. Okay? That is confidential.
firstly, I am going to explain what is overall presentation includes. Meaning of individual liberty and how it be defined under Indian Constitution and what extends to provision of BNSS curtails the individual liberty and how does the provisions of BNS infringes the individual liberty. First, we need to know what is significance of Bharatiya Nyaya Sanhita 2023. Bharatiya Nyaya Sanhita 2023 represents a significant reformation of criminal justice framework in India. It has aimed to balance individual liberty with the need to form effective law implementation. This legal overhaul seeks to modernize the criminal code, addressing contemporary challenges fundamental rights. Now we need to know what is individual liberty. The concept of individual liberty was recognized under Magna Carta and US Constitution. The individual liberty refers to the right to freedom and liberty are guaranteed to the individual, protecting from the undue interference by the government and other individuals. Under Constitution of India, the right of life and personal liberty includes the broad range of rights such as right to live with human dignity, the right to livelihood, the right to privacy, the right to medical aid, and the right to fair trial. It is all protects against arbitrary detention and torture. Some certain provisions of BNSS, that is Bharatiya Nagarika Suraksha Sanhita, the new Criminal Procedure Code of India, have the potential to infringe upon the fundamental rights. The provision related to arrest and detention. The section 54 of Bharatiya Nagarika Suraksha Sanhita 2023 allows police officer to arrest individual without warrant under certain conditions. Arbitrary and excessive use of this power can lead to wrongful arrest and detention. Violating the right of personal liberty if the condition or arrest are strictly followed or interpreted too broadly, it can result in deprivation of liberty without due process. Prolonged and pre-trial detention. Section 167 of permits the detention of an accused for up to 15 days by a magistrate, and further it expands to 90 days for crime punishable with death penalty and imprisonment of life, like this. Prolonged detention without a timely and fair trial can infringe on a person's liberty. Delays in judicial process can result in individuals spending excessive time in custody without being proven guilty. Next, provision related to search and seizure. Section 93 allows us for search and seizure operation
protection based on the direction of enforcement. If not conducted with appropriate safeguards, search and seizures operation can violate personal privacy and liberty. Unwarranted or excessive search and infringes on the individual right to privacy, which is an intrinsic part of the right to life and personal liberty under Article 21. The provision relating to custody and custodial interrogation and treatment. Section 53 of BNSS authorizes the examination of the accused by a medical practitioner at the request of police officer. This provision can misuse to subject individual to medical examination without proper justification, infringing on their bodily autonomy and dignity. And provision relating to denial of bail. Section 436 to 439 concerns the provision for bail in bailable and non-bailable offences, with the judiciary having a discretion in granting bail. Denial of bail, especially in non-bailable offences, without sufficient cause and result in prolonged pre-trial detention affecting the personal liberty. Overuse or misuse of this discretion can lead to unfair deprivation of liberty. Next, provision relating to summary trials. Section 260 provides the summary trial of certain offences which are seen as less severe. Summary trial expedite the legal process but can sometimes compromise the right to a fair trial. If due process is not strictly followed, it can lead to unjust conviction infringing on personal liberty. Further part of a presentation will continued by my co-author.
Thank you. Next, paper presenter, P4, code number P4 will present on the topic role of technology in criminal justice system in India.
Hello. A very warm good evening to one and all present here, respected dignitaries, and all the eminent personalities who are present for this auspicious occasion. Today I am going to present my paper which is entitled as Role of Technology in the Criminal Justice System in India. Technology, as we all know, is the greatest weapon in the 21st century. The application of scientific knowledge into the problems of daily life has accentuated the creation of something bigger, which proved to be of immense value for the life of mortals to carry out their ordinary and sophisticated works. The use of technology can be implemented in a wider stream by potentially using its potentiality. Now, getting to the role of technology in the criminal justice system in India with slight introduction into the criminal justice system. As we all know, the criminal justice system in India comprises of all the machinery for solving the crimes of the country and for the establishment of law and order in the society. It protects the citizens from violation of their rights, liberties, and to be more specific, serves as a guardian angel to their life in particular. The criminal administration in India has several laws in it. It can be broadly substantiated on the basis of whether they are substantive or procedural in its aspect. Some examples are the Code of Civil Procedure of 1908, which is a procedural law which lays down the procedural aspects of adjudicating crimes. It would be renamed as Bharatiya Nagaric Surasha Samhita, which will be effective from July 1st. The Indian Penal Code of 1860, which is a substantive law which defines rights, liberties, and certain do's and don'ts concerning citizens of the country. It has been renamed as the Bharatiya Nyaya Samhita, which will also be in effect from July 1st. The Protection of Civil Rights Act of 1955 is also a part of this comprehensive system. It was passed to abolish practices such as untouchability and to secure equal rights for equal citizens in the country regardless of the distinctions based on caste, creed, color, etc. The structure of the criminal justice system includes four main pillars: the investigative process by the police department, the process of prosecution of the case by the prosecutor, and determinatory process of the court, and finally the process of correction if proved existence of hysteria. Now, getting into what all technology can be incorporated in the different arenas of criminal justice system, answering with the help of a slight peek into the facilities which are available with itself. The initial step, of course, lies in the speedy conduction of investigative process. The development of forensic technology in understanding the irregularities which are unnatural related to crime scenes are definitely a start. The improvement in face recognition software, which is on the move now. Moreover, the improvement in the field of biometrics, voice technology, AI, vehicle-related combined data, GPS tracking, cyberwing, DNA profiling, etc. can be thought of and will be really helpful. The next step is the trial. The use of Google Meet for the conduction of trials is an innovation that is going on now. The inclusion of speech-to-text technology when the judges write the arguments in the court would be really helpful and save a lot of time in the court. The paperwork should be rely entirely on the electronic media in most of the courts and advocate offices. Even if it is there, it will be much more helpful if it is improved in the uniformly across the entire country. And next is the security systems which are similar to appearance should be used for gathering of data related to the different cases. The next discussion should be about detention. Jailbreaking is a critical issue that needed to be addressed. To prevent that, automatic recognition software should be included which fetches the information of the offenders using their fingerprints or retina scans. Separate jail systems based on the grievousness of the crime should also be implemented. Now, getting into what implications of the technology, more particularly the use of AI in legal profession in India with special consideration to criminal law. AI hasn't been used most widely in the legal spectrum because it was believed that it is not competent to be used in a wider sector. AI has been a continuous source of conflict which can be seen in several cases like Kirti Deotra versus DRDO, the state of Kerala case, etc. Since 2001, AI has been made used by the courts to provide process information for the judges for the facilitation of decisions on their part. But as already mentioned, they have a limit in its usage as it does not really participate in the decision-making process. A tool which is used by the Supreme Court of India is SUVAS, Supreme Court Within Anwar software, which has the ability to transform English legal papers to the respective vernacular languages of the people. To know the wider perspective in a case, the presiding judge of Punjab and Haryana High Court of the case Jaswinder Singh versus State of Punjab used the help of ChatGPT. The reference by the court was completed to have a broader perspective of the case which didn't have an effect to expressly imply the merits and other technical aspects of the case. Now, the presence of technology in Evidence Act of 1872 and the various inferences drawn from it. It had been included in order to know the relation between law as well as technology. According to section 65B1 of the Evidence Act, any information in an electronic record printed on a paper, stored or recorded or copied in an optical or magnetic media produced by a computer shall be deemed as a document. So electronic related evidences are on the move now because it is much more accurate than manual evidences. Before concluding, I would like to say that since the dawn of humankind, it has been on a race to find out how to live their life with much ease. With the introduction of technology, that help and that wish have been furthered. So, with the help of the technology, different kinds that have been used to facilitate different kind of crimes in the country can be used to facilitate them and negate the different crimes. As India is the fastest growing economy in the world. Thank you.
The next presenter is P5. Code number P5 will present on the topic effectiveness of new provision relating to investigation and prosecution.
Good afternoon, everyone. Today the topic of my presentation is effectiveness of new provision relating to investigation and prosecution. India's criminal justice system has been predominantly shaped by laws and regulations inherited from the British colonial era. In the post-independence years, these legal foundations underwent alterations, alterations, alterations amendments to align with the evolving requirement of modern times. The experience of over 7 decades of Indian democracy call for the comprehensive review of our criminal laws, including the Code of Criminal Procedure and adopt them in accordance with the contemporary needs and aspirations of the people. The Bharatiya Nagarika Suraksha Sanhita, which seeks to define CRPC, address the challenges faced by the judiciary in the criminal justice system. What is the objective of BLSS? It gives fast and efficient system in governance. However, delay in the delivery of justice due to the complex legal procedures, large dependency of cases in the court, low conviction rates, low level of use of technology in the legal system, delay in the investigation system, complex procedures, inadequate use of forensics are the biggest hurdles in the speedy delivery of the justice, which impact poor man adversely. The VNSS provides for the use of technology and forensic sciences in the investigation of crime and furnishing of information, services of summons, etc. Through the electronic communication, specific timelines have been prescribed for the kind of investigation, trial, and pronouncement of judgments. Citizen-centric approaches have been adopted for the supply of copy of first information report to the victim and to inform them about the progress of investigation, including by digital means. Next, I will explain some major changes introduced in the new legislation. First one, integration of technology in legal process in the section 227, clause 1, subclause 3. Introduction of use of technology in various legal proceedings such as serving summons, notice, and warrants electronically, enhancing efficiency and reducing paperwork. Introduction of zero error in section 173 clause 1. The VNSS facilitates the filling of zero errors for the offences occurring outside the jurisdiction of police station but within the state. Use of handcuffs during the arrest in section 43 clause 3. It provides guidance for the police officer to use handcuffs when making arrests, considering the nature and gravity of the offence. Recording of confessions and statements in section 183 clause 6. The Samhita requires judicial magistrate to record the statements of witnesses brought before them by police officer in case with several penalties. Forensic evidence collection for the serious offences under section 176 clause 3. It mandates forensic teams to visit the crime scenes to collect the evidence through the electronic device for offences punishable by the imprisonment of 7 years or more. Establishment of a Directorate of Prosecution, section 20. The VNSS defines the role and power of the Directorate of Prosecution, headed by the Director Prosecution functioning under the administrative control of the Home Department of each state. The VNSS introduced the right of victims to get free of cost the copy of file in section 173 clause 2. In case of arrest by a private person, section 40 of the VNSS has been amended to take it mandatory for the such arrested person to be produced before a police officer within 6 hours of taken to the nearest police station. Section 154 of clause 2 of the CRPC requires that a copy of the recorded information be supplied only to the information. However, section 173 clause 2 of the VNSS requires that copy be sent to either informant or victim. Section 173 of clause 3 of the VNSS is a new provision dealing with the concept of preliminary inquiry. It states that if a police station receives information about the commission of cognizable offences punishable for 3 years or more imprisonment, but less than 7 years, the officer in the charge may conduct preliminary inquiry with the permission of a deputy superintendent of police, depending on the nature and gravity of the offences. The new legislation specifies crimes and imposes punishment. Procedural law is in charge of the implementing substantive law. The whole framework of criminal process code is based on the three fundamental considerations. A fair trial should be proved to an accused individual in accordance with the acknowledged natural justice standards. Every effort should be taken to avoid inquiry and trial delay, which are harmful to the individuals involved and society. The main amendments that new legislation proposed would have big influence on India's criminal justice system. With this, I conclude my presentation.
Thank you. So next paper presenter is P6, a presenter on the topic major changes in the new legislation to address
legislation.
Good afternoon, everyone. Now I will present the paper regarding major changes in the new legislations to address the contemporary issues. Law is said to be a set of rules and regulations to control the outer behavior of human agency. A strong and powerful legislation will serve justice to society. The three new legislations will be able to protect all the rights which are enshrined in the Constitution. The Bharatiya Nyaya Samhita significant changes in BMS Act are Section 69 of BMS provides punishment for sexual intercourse by employee of physical means. Earlier in IPC, this provision was not available. Section 52 of BMS identifies the organized crime. Earlier in IPC, this provision was not available. Offense of Terrorist Act. Section 113 of BMS analyzes terrorism involving act intending to likely to threaten India's unity, integrity, sovereignty, or economy to instill terror in people domestically or abroad. Earlier in IPC, this provision was not available. Sedition. Section 152 of BMS introduced a new form of sedition with imprisonment which may extend to 7 years. Fabricating false evidence. Section 298 of BMS states regarding fabricating false evidence, the punishment is provided under 299 with imprisonment which may extend to 7 years and shall also be liable to fine. Mob lynching. Section 103 clause 2 of BMS provides punishment for mob lynching. Earlier, mob lynching was not recognized by ICC. The Bharatiya Nagariga Suraksha Samhita. Significant amendments in the legislation are procedure for investigation. BMS Section 176 Clause 3 states about procedure for investigation. It also requires the forensic investigation for which crimes are provided punishment with imprisonment of 7 years or more. Information in public cases. Section 173 of BMS provides electronic mode for all trials, inquiries, and proceedings. The concept of zero FIR, that is, registering the FIR regardless of jurisdiction, is provided under Section 193, Clause 1 of BMS's. Enquiry and trial. Section 356 of BMS's provides for enquiry, trial for judgment in absence of the proclaimed offender if he avoids trial by absconding. The judgment can be given in their absence. Power of magistrate to order specimen signatures or handwriting. Section 349 of BMSS extends this power of magistrate to include fingerprints, voice sample, even from someone not arrested. Forms of summons. Section 63 of BMSS states every summons may be in writing or any other form of electronic communication signed by the presiding officer of the court. Medical examination of the victim of rape. Section 184 of BMS provides medical examination of victim of rape. It provides that the registered medical practitioner shall forward the report of examination of victim of rape within 7 days. This provision establishes a specific time frame for supply of medical reports and streamlines the overall process of supply of documents. Witness protection scheme. In earlier CRPC, the provision of witness protection scheme was not available. Section 398 of BMSS provides for witness protection scheme. It mandates the preparation and notification of a witness protection scheme by every state government. The necessity of a comprehensive witness protection scheme has been understood by Parliament Committee and various law commissions. The Bharatiya Saksha Adhiniyam. The BSA replaces the Indian Evidence Act of 1872. The Act strives to establish general rules and principles of evidence for a fair trial, adapting to technological and societal changes over recent times. Definitions. The definitions given under Section 3 and 4 of Indian Evidence Act were not arranged in alphabetical order. Section 2 Clause 1 of Bharatiya Saksha Adhiniyam provides the definition and all the definitions are arranged alphabetically with serial numbering. Document. Section 3 of IEA defines the term documents. Section 2 clause 1 of VSA includes electronic and digital records to the definition of document. Evidence. Section 3 of Indian Evidence Act defines the term evidence. Section 2E of VSA defines evidence. It includes digital records within the documentary evidence. Provisions relating to confession. Section 24, 28, and 29 of Indian Evidence Act states regarding confessions. In Section 22 of VSA, all the above sections are scrapped and the word coercion is added. Relevancy of statements as to any law. Section 38 of IAA states about the statements to any law contained in law book. Section 32 of VSA states about the statements as to law contained in law book, including electronic or in digital form. Primary evidence. Section 62 of Indian Evidence Act defines primary evidence. Section 57 of VSA added explanations to the definition of primary evidence. Secondary evidence. Section 63 of IAA states regarding secondary evidence. Section 61 of VSA added new categories as secondary evidence, oral admissions and written admissions. Thank you.
Thank you. Next paper presenter is P7. Will present on the topic adoption of artificial intelligence by the courts in the administration of justice. Over to you.
Hello. Hello.
Booting with the problem. Hey, with.
Hello. A very good afternoon to everyone present here, respected jury members, co-participants, and all the audience present here. And today I will be presenting on the topic adoption of artificial intelligence by the courts in the administration of criminal justice. To begin with, what an artificial intelligence is. It is a computer or a computer-controlled robot's ability to perform tasks commonly associated with the intellectual processes, characteristics of humans, such as the ability to reason. Now, I would like to say that artificial intelligence and machine learning are like the brain. Now, I request the jury members to kindly refer to flag 1 of the report, where it is the Robotics Informatics Center, the National Informatics Center has established a Center for Excellence in AI 2019 to explore more opportunities for AI applications in governance. It has also defined what an artificial intelligence is. Now, coming to the root problem in the criminal justice system. Firstly, the burden of unresolved cases. There are a number of cases that rose above 5.1 crores in the year 2024, and pendency of cases in all the levels of court is a challenge for the judiciary, especially the criminal justice system. So the Ministry of Finance study found out that it takes on an average almost 20 years for property related dispute to be resolved, and nearly 324 years to clear the present backlog. And now these unresolved cases has a ripple effect, especially and the most promising and powerful tool in the criminal justice system. So AI technologies such as advanced machine learning algorithms, natural language processing, and predictive analytics, legal professionals can efficiently and effectively analyze vast and diverse data sets. So I request the jury members to refer to flag 2 of the report, where the number of translated judgments per language is being presented. And secondly, it improves the overall efficiency of the judicial system by deploying automatic, repetitive, and time-consuming tasks such as case management, legal research, and document analysis. Judicial stakeholders can significantly improve all that. And what is the impact of this AI on the criminal justice system is that the judiciary has certain tasks that it has to perform. And AI helps in all these things. Firstly, in reading and analyzing documents, summarizing documents, contents, case law, and legal code research, using visualization and predictive analytics for settlements, administration, and assistance on bail, parole, and probation matters as well. Now, there are benefits and challenges and considerations as well of AI in the criminal justice. Now, the certain benefits are it enhances crime prediction and prevention, efficient investigation and evidence management, bias reduction and resource optimization, enhanced community engagement, and accelerated innovations. Now, there are certain challenges and considerations that should be taken into account. Firstly, being with respect to the data privacy, algorithm bias, transparency of decision-making process, ethical issues, and development of legal framework with respect to ethical standards. Now, there has been recent developments and initiatives in India with respect to the AI in the criminal justice system. Firstly, the NITI Aayog formulated the 7 responsible principles of AI, and it also released an article AI for all in order to bring awareness among people to make use of AI in a supervised and ethical manner. And secondly, the e-courts project as well, the jury can kindly refer to flag 3 of the report. And also the SUPACE, which was introduced by the Supreme Court, which stands for Supreme Court Portal for Assistance in Court Efficiency. And another initiative by the Supreme Court was SUVAS, that is Supreme Court Vidik Anuman software. So, in my Pew research, there has been new findings as well at the global level how the other countries have been using AI in their criminal justice system.
Whether all these things involve cognitive computers or artificial intelligence.
Artificial intelligence.
So this classification is not artificial intelligence.
Artificial intelligence.
I should say it's a function.
It's a software that
It is a software, yes, that's it. Software is there, we are using. You are using, is there anything artificial intelligence in your laptop?
artificial intelligence is part of advanced technology. Machine learning and the language processing is all part of artificial intelligence.
Huh? Silent.
Artificial intelligence is something that is used for the advanced technology just to make our work easier.
You give us a very simple example how artificial intelligence can be used in any
Now, if I have to search any of the case law, or if I have to research anything, earlier it was like we used to have books, we referred journal articles, and it was a very time-consuming process. Now, because of advancement of technology and artificial intelligence and development
it is like this. What you are saying is you are speaking about the search engine. Okay. If I want to dig out case law, I need a search engine.
yes.
One of our guys is so some search engine. Like that, ACC also had its own citation search is there, copying is there, etc. There is nothing artificial intelligence.
So if I have to say that artificial intelligence, the definition
we have done it. Indeed, yes. It is working on it. That might, I think that might be a problem.
And the search engine is working as designed as the function trainer. Right?
Yes, yes, yes. So now, just to give a very simple example, now you're asking me a question, and now it's a how to respond to it. It is my intelligence and how I respond to it. Same in a manner, the computers and other technologies, until and unless we input something, it will respond us back. Right? So that is the artificial intelligence. But it's part of computer. Now, the USA has adopted this KILPAR, which is Correctional Offender Management Profiling for correctional offender management profiling for alternative solutions. So please refer to slide 4, where it states the objectives and life cycle of how an offender moves through the country criminal justice system. So they now recently they have also introduced the ROS intelligence that is created to assist lawyers by reading and understanding legal text, performing legal research, and also providing cited answers to complex legal questions. And coming to the United Kingdom, the UK Ministry of Justice in 2020 introduced the digital case system for Crown Courts. So this system provides real-time case updates, facilitates remote court participation, and also allows for digital submission of evidence. And the same report has been submitted at the flag 5. Lastly, I would like to conclude by saying that as AI progresses, AI progresses and becomes increasingly integrated in the criminal justice system, policymakers, legal experts, and all the stakeholders need to collaborate closely. However, it is essential to address the challenges associated with AI, such as algorithms, basics, and transparency, to ensure that the benefits of AI are realized without compromising the fundamental principles of justice. Thank you.
So next paper presenter is P8. Will present on topic silence on marital rape in the criminal law.
Thanks to all the learned judges and my fellow presenters. We get to know about the sections, procedures, and the changes. However, I would like to talk about the one concept which has been neglected and been silent on throughout many years, and that's the absence of marital rape in Indian provisions. Good afternoon, everyone. My topic for my today's presentation is silence on marital rape in New Criminal Law Bill 2023. Before moving on to what is marital rape, let's see what marriage is. Marriage is the union of two people who have mutual regards for one another, and it is considered as a sacred bond. Now, what is marital rape? It is defined as a non-consensual sexual intercourse with one spouse. According to UN Women's Report in 2018, an organization which promotes women's legal rights observed that 1 in 7 women had experienced physical or sexual violence from an intimate partner or her husband. A whole new chapter dedicated to women and children has been added and in the new criminal law bill. However, the marital rape continues to be an exception to the sexual violence law. And India continues to be the one of the odd 34 countries in the world who have not criminalized
not criminalize the marital rape. Section 375 of ADC 1860 states that rape is a rape as non-consensual sexual contact with a woman, giving exception of while not being under the age of 15 years. However, the age has been increased in 2017 to 18 years in Independent Thought versus Union of India. This desperately highlights the concerning absence of legal safeguards for the woman of 18 years and above. In 2005, the Protection of Women from the Domestic Violence Act was introduced and recognized marital rape as any other form of sexual violence and domestic violence. However, the protection of the victims under this act is too insufficient and falls short of addressing the gravity of the issue. UN also recognizes and urges countries to close legal loopholes and said that house is one of the most dangerous places for women. Before moving on to why it should be criminalized, let's see what are the reasons given by many people who believe that criminalizing rape in marriage will be detrimental to Indian society, and these also act as challenges in criminalizing the same. It would oppose the marriage institution and become an easier way for harassing the spouses. And second is sexual acts with partners cannot be recorded as evidence in the court, as there will be no solid lasting evidences in those cases. In 2016, an Indian official in Rajya Sabha stated that the concepts such as marital rape cannot be applied in a country such as India due to the factors like poverty, illiteracy, social culture, faith, and social norms. Women may feel pressure to report this act due to social stigma, child impact, and family shame. And in most of the cases, because of their dependency on their husbands. One of the on the same, the spouse's testimony will be the only evidence of the rape, and it is impossible to prove the absence of the consent. Well, of course, these will be the problems and challenges while enforcing the act. But now let's see why it should be criminalized. First and foremost, no, marriage cannot be viewed as a license and or the consent for the spouse to coerce sexual relations on demand. It does not mean irrevocably implied consent. Secondly, it violates the basic fundamental rights such as in Article 14, 15, and 21, etc., and strips away the dignity and freedom of choice and the autonomy of the body. It is a crime against humanity and is the most heinous violation of the one's integrity. Criminalizing marital rape gives women the basic human rights while also giving her a sense of security inside her own marriage. Most importantly, it will provide a direct legal remedies and safeguards for seeking the justice which we are lacking now. And lastly, there are many impacts on the victims as physical and mental health consequences, social isolation, which in turn leads to loneliness and depression. And once victims become trapped in this cycle of abuse, there is no escape. And it also leaves them with difficulties of forming a healthy relation and trusting others in the society. Um, However, we all have seen and known the cases where which are against the husband and talks about the safeguards and protection of wife's rights. We cannot turn blind eye and rule out that wife who had never perpetrated cruelty against her husband. In the landmark case of injury, Dr. N.G. Dastani held that cruelty are of two types, mental and physical, and it is also considered as one of the few cases where the question is against the woman and not the husband. And there are many cases where wife has wrongly accused of her husband for cruelty and sexual assault. Hence, the provisions of marital rape must be made gender neutral. Lastly, I would like you guys to ask this question yourself that after marriage, is the consent of the partner for sex is not necessary? Is there any difficulties in trauma and is there any differences in difficulties and trauma faced by a 14-year-old and 21-year-old in
goes. Does woman have no right of her own body after the marriage? Is marital rape violating the fundamental rights given in our sacred constitution? Well, while the answers can be silent, the questions will never be. Because the rape is a rape, it will be, and if it is a marital or non-marital, victim is a victim. And the rape is never the victim's fault. Thank you.
Thank you. So next paper presenter is P9. He will present on the topic, the present scenario of the criminal jurisprudence in India.
Dharma Rakshiti Rakshitaha. When we protect Dharma, Dharma will surely protect us. A very warm good afternoon to everyone. The topic that I am going to present is the present scenario of criminal justice in India. Before I go into my topic, can I just briefly say why law, why rule, and inflation came into existence? As we all know, we live in a society where we call it a society had a name called as primitive golden age, where there was no existence of rules, regulation, or laws. The only reason behind that was the concept of the innate goodness of the people. And simply I need to say that because of the innate goodness of people, there was no laws, and today the laws are there. It is only because of the character we are doing and the problems we are ourselves creating in the society. Okay, now I will move to the concept how the concept of law has evolved in India. Okay, I have seen many of us praising the IPC, CRPC, the evidence, such things that came from British or someone from not from our country. Just why we forgot to say that we had a great Manusmriti written by the great scholars of India, which has clearly defined many of the sections, articles, and the very things which are clearly defined in the IPC, CRPC, even behind centuries behind. The Manu has represented robbery, theft, slavery, assault, and sexual harassment, many things within it. It clearly states that we have everything within us, but we are ready to take something from others. Such a confident country starting to adopt the concept of others was a decline in ourselves which we created in it. For example, see, when the Home Minister was presenting the same bill of BNS and other stuffs of newly implemented, he clearly stated that even after 75 years of independence, we are living in a country where they still use the word of British, crowns, barristers, all the stuff which are used by the foreigners. Why don't we use the words which we have beautifully declared? Well, that is the thing, all the stuff is bringing back, that is to BNS, using our own things. And it is bringing to what we needed, not what Britishers needed. As we say about amendments, I simply say that amendment is the key concept where people can bring a certain changes in the society and that to bring a balance in the society. As we all know the concept of यथा यथा हि धर्मस्य ग्लानिर्भवति भारत अभ्युत्थानमतस्य धर्मस्य तथापरं सृजाम्यहम्. It simply states that when bad outweighs the good, someone will come to repeal and make it in a proper order. I think myself feel that now we are in the present situation where someone and something should change our laws to protect us from the outweighing criminals and the increase of crime rates in the country. I personally feel that BNS is one of such concepts which is coming in the form to make amendments and that will reduce the crime rate in India. Why I say amendments is that simply one of the heartbreaking case we all know that was Nirbhaya case, which happened in the year 2012, December 16th. What was the total, when they said that judgment was done fast within 1 year, we got all the culprits in hands. Do we feel that judgment was done? No. The concept of a juvenile or presently where we don't use the word in BNS as juvenile, we call it child. A concept of that was a question mark there. Why? Because we didn't have a proper amendment to maintain or punish that child who has committed such a heinous crime. In Nirbhaya case, lot of amendments was done. And we know that rapist who has committed the rape there was hanged in the year 2020. When we compare the rate of the rape and the date when he was convicted or the when final punishment was given to him, the people were like 8 years. As
is blessed with an innate nature talent to give a birth, where that same woman was used for the purpose of money making and economy in the society, only for giving birth to someone else who she had never met. This created a problem in India where we worship women as God and we sell herself for money is created a very shameful Indian countries. And finally, it leads to the amendments that after this case, certain amendments in surrogacy has arrived, and that amendments led to a certain decline of surrogacy and surrogation regulation act. As I conclude by saying, BNS, all the IPCs, BNS or something that has changed presently, all the three bills or the act that has came, it's simply aiming to bring changes in the society that we all outweighted still now. For example, in BNS and all the three things, they included many amendments. Some of them I will mention here, that is rape and the offenses like terrorism and the kinds of robbery, theft and many other things. And you know, India is a developing country where AI everything is a fashion nowadays, and we don't have a system of electronic representation of crime in India. In such a time, now we all awaited for such a change in our country, and presently we are getting all such changes, and the speedy justice system was the one we all awaited still now. I conclude by saying that BNS and all the acts that were present brought in the country will really bring a change in the country, and the entire crime rate of the country will reduce. Thank you, my lord, for giving us.
Moving to next paper presenter. Code number P10 will present on the topic, the elimination of the need criminal laws, a critical analysis.
Good afternoon, one and all. Today I'll be presenting my paper on the limitations of the new criminal laws. So our criminal justice system dates back very long, from the Vedic period Dharma guidelines to the Sharia laws to the introduction of code and codified laws in the 80s by the British. So this replacement of laws of IPC, CRPC and Evidence Act is due to the realization that they are outdated, colonial and oppressive laws. So the new laws are said to be based on the principles of equal treatment, human rights and individual freedom. But today I will be presenting some requirements of the time that are ignored by the legislatures that can lead to potential injustice, violate constitutional rights and international conventions. To go with marital rape exception, as our great leader Swami Vivekananda says, a bird cannot fly on its one wing. In the same way, a country that does not give a woman its rights place will not grow potential. So the same registered exception to of section 375 of IPC that expressly decriminalize marital rape is reiterated in the section 63 of exception to of Bharatiya Nyaya Samhita. So why did all this start? In the 1900 BCE, rape was considered as a property crime because women were considered as the property of husband or father. But and we copied the same from the UK, right? The common law. But the position changed in even UK in 1991 in the case R versus R, and now they have punishment up to 40 years. And 150 countries out of 195 countries have already criminalized marital rape. And we still cannot give the reason that it will destroy our family institutions. Because countries like Nepal and Bhutan, which have very closely interlinked social and cultural tradition as ours, have criminalized marital rape as well. But in India, 82% of women says that there is sexual violence in their time of marriage. 9% says there is sexual violence in their form of marriage, according to the National Family Health Survey. And we have to also understand that it is underreported most of the times, and the statistics can be more. It violates the Article 14 because equal protection of law is not given. Article 15 because state is considering them subordinate if you interpret. Article 19 clause 1 clause A because the freedom of expression of sexual agency and autonomy is violated. Article 21, the right to life, dignity, and privacy is violated because she is not independent to choose if she should have intercourse or not, or when to have and when to not have. It also violates the Universal Declaration of Human Rights and the Protection of Human Rights Act 1993 that India enacted, and the two conventions that to which India is a signatory, which section of laws that will lead to violence against women. And also, the committee that was set up after the horrific Nirmaya gang rape also recommended the same. I do take note of all the Dowry Prohibition Act and other special legislation that are enacted to protect women against violence. But my concern is the conviction rate, which is 21%. So why enact special legislation when in the criminal laws can be implemented effectively? And also, those two cases where the judges have opined that they're unconstitutional and violates the rights guaranteed by the Constitution, and there are so many cases pending in the Supreme Court, which will also give effect to the mental health of the victims here. The National Institute of Health says they suffer from post-traumatic stress disorder and also clinical depression that can lead to death. The second limitation that I find is no provision for sexual offences against men, transgender, and animals. The only provision, that is Section 377 of IPC, that criminalized bestiality and non-consensual unnatural sex after the Navdeep Stover versus Union of India is now not there. Even after the Parliamentary Standing Committee recommended that it should be there in the Bharatiya Nyaya Samhita 2023, in a country where we have just one legislation for the protection of animals, and that lists all the Section 11 lists all the offences that can be punished. It does not mention bestiality. In a country where two reports, the fourth and fifth one, says that in the last 1 decade there were 5 lakh sexual abuses of animals. So we all know there is lack of sex education in our country. Almost all the youth they depend on pornography to learn sex education, right? And we know how this website fantasizes bestiality and non-consensual sex. So this all is an indicator towards human violence also. These two cases have upheld that even animals have the right to life, to live a dignity just like humans. And we have the right to protect them. You need to protect them under Article 15A Clause D. And the state has the duty to protect them. And the concurrent list is the doctrine of parents patriarch, which says protect those who can't protect themselves. And what about women transgender rights? The patriarchal notion that they are the perpetrators and they cannot be violated or vulnerable does not stand anymore. Even men go through rape, and this is the percentage, and they also go through same mental and physical health affected just like women. And transgender, we know that they have been suffering from that in the recent cases, they fight everywhere. And this legal loophole can be so huge that because the perpetrators literally cannot be booked under any law. It means that this all is decriminalized because there is no law that criminalizes these acts. The third one I found this is extension of police history, which the legislative error in the section 187 clause 3 of ESS removes the word term otherwise in the police custody, which can mean that we are going from due process model to crime control model, so there is an imbalance between individual rights and societal rights. These are the statistics, and these are the cases that say that it is very unconstitutional and it destroys public confidence in the criminal justice system. So, to conclude, our constitution is not just enacted as a tool of liberation from British rule; it was enacted as a document of social transformation. As the National Human Rights Commission rightly points out, the government is very much responsible and accountable for all kinds of human rights violations in its jurisdiction. The country has the duty to protect and prevent, not just to be reactive. So unless the parliament enacts very inclusive and effective laws, lakhs of them will get their human rights violated and thousands of them will keep committing offense with impunity. So let's not fail as a system by being reluctant. Thanks a lot.
Thank you. Moving to next paper presenter, the code number P11 will present on the topic major changes in the new legislation to address contemporary issues.
A very good evening. A very good evening to all the dignitaries present off the dais and to all of them present present here. It is my immense pleasure to stand on this prestigious stage to present my paper on major changes in the new legislation to address contemporary issues. As I begin with my paper, we first need to know what was the need to bring these major changes in the present legislation. The Indian Penal Code 1860, the Code of Criminal Procedure 1976, and the Indian Evidence Act 1872 are like the three big structures of India which impacts every Indian. But in the last 100 years, the nature of crime, the method of crime, and criminals, all of them have changed drastically. And to be honest, 100 years ago, how could anyone have thought that there would be a crime called cybercrime? That's why the Parliament has decided to replace these three laws with the new criminal laws, that is, Bharatiya Nyaya Sanhita 2023, the Bharatiya Nagrik Suraksha Sanhita 2023, and the Bharatiya Sakshya Bill 2023. The problems in the existing laws are that these laws were made by the Britishers. Sir Amit Shah said that in these laws, still in more than 400 places, the British term is mentioned, which even after 75 years of independence shows the colonial slavery. Apart from this, there are other problems in the existing criminal laws, like they are not gender neutral, they have complicated structure, etc. And all of these problems have been addressed in the new laws. Moving on to what are the major changes that are brought in the new legislation to address the contemporary issues.
There are many changes and modifications that have been taken place, and I will be taking some of the major changes. Firstly, moving on to Bharatiya Nyaya Sanhita 2023, which has taken the place of Indian Penal Code 1860.
Terrorist Act, which is under Section 15 of Unlawful Activities Prevention Act 1967, has been adopted under Section 113 of the revised bill, but the definition has widened. It includes the production or smuggling or circulation of only high quality counterfeit Indian paper currency, coin, or any other material within the ambit of terrorism and the UAPA. Whereas the revised bill widens this definition to cover the same activities with respect to any counterfeit Indian paper currency, coin, or any other material. Also, according to this section, an officer who is not below the rank of superintendent of police can decide if the prosecution of a terrorist act should continue under UAPA or Section 113 of this bill. This offence is punishable with death or imprisonment of life. Next, moving on to Section 73, which is the newly inserted section, talks about unauthorized publication of court proceedings. It specifies that those who print or publish any matter concerning court proceedings in rape or sexual assault cases without permission would be punished with a 2-year jail sentence and a fine. However, it also clarifies that High Court and Supreme Court judgments would not amount to an offence within this provision. Next, going on to Bharatiya Nagrik Suraksha Sanhita 2023. In this, firstly, community service has been defined. Section 23 of this bill defines that community service is a work which the court may order a convict to perform as a form of punishment that benefits the community, for which he shall not be entitled to any remunerations. Moving on to handcuffing, the Act provides that for the use of handcuffs during arrest, and it may only be used to arrest those people, that is, a habitual or repeat offender who has escaped custody, or a person who has committed offences such as rape, acid attack, organized crime, drug-related crime, or offences against the state. And also, according to the new bill, the detained person must now be produced before the magistrate or released in petty cases within 24 hours. Lastly, the Bharatiya Sakshya Bill 2023. The most important addition to this bill is the admissibility of electronic evidence. According to Section 61, the admissibility of electronic evidence is allowed by underscoring that electronic records shall have the same legal effect as a paper record. And according to Section 63, there is no requirement for a certificate. I would like to conclude my paper by saying that the recent legislative changes mark a significant step towards addressing contemporary issues by incorporating modern needs and values into the legal framework. The new legislation aims to create a more adaptive and just society. This proactive and holistic approach not only addresses current problems but also lays a robust foundation for a sustainable and equitable future, ensuring that laws evolve in tandem and societal progress. I would like to thank everyone for giving me this opportunity to present my paper. Thank you.
Next paper presenter is T. Raj. Will present on the topic Induction of New Technology into Administration of Criminal Justice.
A very good evening to respected sirs and madams and everyone present over here. So today I'll be presenting on the topic Induction of New Technology into Administration of Criminal Justice. So in this topic, I will be briefly explaining about challenges of traditional criminal justice methods, potential of new technologies, and benefits of technology integration, and lastly, risks and considerations. So moving on to the topic, this topic is significant because criminal justice system is a fundamental pillar of our society, ensuring the rule of law and safeguarding citizen rights. However, traditional methods have faced numerous challenges that hinder their effectiveness. So, with respect to this topic, firstly, I will focus on the challenges of traditional criminal justice methods. They are inefficiencies. Traditional methods such as manual paperwork and outdated record keeping are plagued by inefficiencies and bureaucratic delays. Resource constraints. Limited resources, including funding and personnel, further intensify these issues. Access to justice. These methods also create disparities in access to justice, especially for marginalized communities. Moving on to potential of new technologies, digital case management system. Digital case management system can organize and track case information efficiently, reducing paperwork and speeding the process. Electronic filing platforms. Electronic filing platforms, which are also known as e-filing platforms, also allow faster, more accurate submission of documents, reducing administrative overload. Here is the most important one, that is virtual courtrooms. Virtual courtrooms facilitate remote participation, saving time and resource, and making justice process more accessible. Coming to the benefits of the technology integration, efficiency. By streamlining process and reducing manual labor, technology can be significantly improve efficiency. Fairness. Technology enhances fairness by ensuring consistent and transparent process and providing equal access to information and justice. There is also some important success stories. For example, some jurisdictions have successfully implemented digital systems that have reduced the backlogs of cases and improved public satisfaction. Example, UAE, Singapore, Denmark, South Korea, etc. So here are some risks and considerations which have to be kept in mind while implementing these kind of new technologies into our system. The first one is data security. One potential risk is data security. It is crucial to implement strong cybersecurity measures to protect sensitive information. And the second one is resistance to change. There may also be resistance to change from the staff accustomed to traditional methods. Training and changing management strategies are to be implemented essentially to make them more efficiently working in the conditions of implementing new technologies in their works. As we have already know that when they introduced a banking computerized system, we know that many of the workers who are working in the banking system lost their job due to the computerization. So here, there is a risk factor also in this introduction of new technology. We have to keep in mind that by introducing new technology, there will be a way to a new way of employment also for the persons who are very intelligent in the way of adopting these technologies in their works. So, and the last one is over-reliance on technology. We must ensure that technology complements and human judgment rather than replacing it entirely. I would like to conclude my presentation by saying that integration of new technology into criminal justice administration offers numerous benefits, including improved efficiency, fairness, and transparency. While there are some risks, they can be mitigated with a proper training and implementation. Thank you, everyone.
Thank you. Next paper presenter is P13. Will present on the topic analyzing the effectiveness of new criminal laws in protecting the interest of women in India.
Good evening, one and all. I'm going to present on topic analyzing the effectiveness of new criminal laws in protecting the interests of human safety. As we all know that on 11th of August 2023, our Honorable Home Minister Minister Amit Shah introduced three new criminal bills, which are Bharatiya Nyaya Sanhita, Bharatiya Nagarika Suraksha Sanhita, and Bharatiya Saksha Adhiniyam. So, which replaces the British and old colonial laws, that is Indian Penal Code and Criminal Procedure Code and Indian Evidence Act respectively. Respectively. So today I'm going to today in my paper I'm focusing on chapter 5 of BNS Act, which deals with the offences against women and children. I mainly focus on women. So, as we all know, that women's safety in India is a complex and multifaceted issue. As Indian judiciary system has evolved along with the numerous incidents such as Nirbhaya case and in Lakshmi versus Union of India, so which violates the vulnerability of women. So this landmark judgment has brought a significant reforms in laws. The government enacted new laws in respect of women. So let's analyze the changes which brought in BNS and how it is useful to women. First, let's discuss the changes which brought and also later the unrecognized area in BNS. So, exception 2 of section 63 of BNS Act states that sexual intercourse by a husband with his wife is not amount to rape if the wife is above age of 18 years. Before in IPC it was age of 15 years, and in BNS they increased the age limit of a wife from 15 to 18 years, which is a positive, it is a positive changes they got, which is brought by the BNS Act. And section 69 of BNS, which criminalizes the offences of sexual intercourse by employing deceitful means, and which shall be punished with imprisonment for a term which is not less than 10 years, and also with the fine. Before in Indian law, there was no equivalent provision for this offence, and here the BNS has brought this provision which preserves the sanctity of marriage and also protect the woman from such offences. So here I want to speak about section 70, which defines gang rape. Before in Indian Penal Code, under section 376B, they define gang rape and they define the offence of gang rape and the punishment, which generalizes all the minor and also the women above the age of 18 under one provision. But here they inserted a section 70 clause 2, which also recognizes the provision, which also recognizes the separately the minor who is under age of 18 years, where like under age of 18 years are considered as a child in a BNS Act, where they need a special provision to address their issues. So it is a nice thing that they bought, they inserted these provisions in BNS of section 70. So now I'm going to speak about the unrecognized areas in BNS. Yes, the BNS has got a exception, like they got a changes. They increased the age limit of marital or married women from 15 to 18 years, but still they failed to criminalize the marital rape, where according to the NCRB report, 70% of the women faces the domestic violence, where marital rape is also a symptoms of a domestic violence. So, and the BNS in IPC there was a in IPC the trans woman was not recognized. Even in BNS they continued to they continues to remain BNS Act, they recognize trans women under third gender, but in section 63 of rape, the trans woman is excluded from the section 63 of BNS Act, which defines rape, where there is even in the case Shivam Santosh Devan versus State of Chhattisgarh, the High Court recognizes the gap in the provision of Section 375 of IPC, which states that rape is done by a male to female, and which does not recognize the trans woman. When the trans woman faces this kind of issue where they want to address their where they want to raise their voice against such offenses. So there is one more section under section 86 to 90 of BNS Act recognizes the causing a miscarriage with or without consent of a woman. If such carriage is to save her life, then it is not considered to be an offense. Where the BNS Act fails to recognize the amendment made in Medical Termination of Pregnancy Act in 2021, the Supreme Court has clearly states that in the amendment that, and it also provides the agency to mother to abort the child irrespective of good faith. In case of Justice K. Putteswamy versus Union of India, recognized right to privacy includes right to make a choice in sexual activity and also a bodily autonomy. As you all know that BNS and IPC, BNS is we take most of the provisions from the IPC which is related to women, and they also made some changes. But it is good that they got some changes, but still they continue to unrecognize some areas which was even unrecognized in IPC also. In 2021, crime against women, according to exact report, National Crime Report of Bureau, 2021, the crime against women cases were 4,28,278, which was drastically increased to 2022 to 4,45,256, where we need a speedy trial and justice.
So before I start, I just have a small request from everyone. I know that I'm the 14th speaker and everybody is exhausted by now, but I please request everybody's attention for the next 6 minutes because a lot of work has gone into this research, so I hope I do justice. So good evening, everyone. I am P40, and here I am going to present my paper on assessing the human rights dimension of the new criminal law bills. So, before I get into my paper, let us first see some statistics. So, some of the statistics to begin with. So, this first graph basically represents the number of complaints that is received by the NHRC and the number of complaints based on the criminal justice system, like how much of violation of human rights is being done in India. So it is a good thing that from compared to 2015 to 2022, it has drastically reduced. But however, there has been a report released by the US in the recent research that is done on India and their watch on the human rights violation in India, and it has been seen that for the past 10 years, the maximum violation of human rights in India is basically done on torture, cruel, and cruel treatment in the prisons, and also inhuman conditions of the jails, lower rate of convictions, and there is delayed justice. So now the other graph basically represents what number of rights are being violated the most in the criminal justice system. So blue is very less, red is often, and green is very often. In that line, we see that human torture and also the other one, I'm sorry, I'm not able to see, but basically cruelty in prisons and cruelty in judicial and police custody has been the most. So now, landmark cases on human rights. So there are many landmark cases on human rights in India, but I have selected the top 4, connecting the same with my research paper. So all the 4 cases have dealt with different issues. So basically the first issue was where section 144 was imposed on a peaceful crowd, and this was said that this is against the violation, it was a peaceful crowd, so it is right against the right against life is basically violated. So Shreya Singhal versus Union of India, I'm pretty sure everybody would have heard it in 2020, wherein there were certain comments posted on social media and section 66A of the IT Act was challenged. But however, the Supreme Court had quashed it and said that it is very broad and vague, and this provision cannot exist because it violates the human rights. Now, without wasting much time, I'm going into the flow of my presentation. So this basically represents my entire paper. So that is abstract, the research questions and methodology I have adopted, the paradigm shift in the criminal law, the rights in collision with law, and what are the conclusions and suggestions from the author, that is me. So now abstract or introduction of the study. So how I have basically started my research is when I was posed with the question that I have to analyze the new criminal law bills. Now as a law student, I would go back to what was there in the society. So I started with how and what was there in the ancient India. So basically evolution of criminal legal system. So it started with dharma. We all have learned it in our semesters about Manusmriti, about the Vedas. So that's how society was basically governed. There was no need of a particular law. People were scared of dharma. People were scared of God. So the society was regulated in that way in India. Then slowly colonial rule came. Just before the colonial rule, there was village panchayat. Slowly there were guards who played the role of police. Then colonial rule came where we got the codified laws on different aspects. Now, what is the role of UDHR, NHRC in the criminal justice system? So UDHR, that is Universal Declaration of Human Rights, and NHRC. So NHRC keeps releasing many reports, many studies on how to improve the Indian criminal justice system. But the question is, have those been considered in the recent bills that have been adopted? Because after independence, this is the biggest amendment done to the criminal justice system, but has it been done properly? Theories of punishment and studies on human rights. So the next aspect of my paper basically deals with how theories of punishment were there. So before there was, inhuman torture to any person who does even a small wrong. Later, slowly people recognized that, the gravity of the offense also should be proportional. So the punishments were, introduced accordingly. But later on, currently, coming to the current situation, my research questions are 2 things. To what extent do the new criminal law bills incorporate the human rights perspective? Have the lawmakers considered this perspective enough? Is the approach adopted to replace the 3 new criminal law bills the right approach? The methodology I have used basically a doctrinal research methodology, including I did a little bit of primary research by consulting with few legal practitioners as well. So, paradigm shift in criminal laws. So, since I have very less time, I'll just concise my entire paper in few points. First main point is dual approach. So the approach that should have been adopted by the lawmakers is basically while they are bringing in new procedures, they have to also consider if the existing system or infrastructure is well enough to take in all those considerations. Like we are already, undersourced system. Imagine bringing in more technological stuff, in evidence. So it is a good thing. It is not a bad change. But how prepared are we for such changes? And how much is that going to affect the rights of the poor people? Then next is basically the central question, that is, does this
initiative become a missed opportunity for a meaningful amendment. Like I said, after a long time, we have decided to change the colonial laws. But has it come to a proper conclusion? No. So, I'll just go to the conclusions and suggestions drawn from my perspective. Since today's seminar is all about, the changes and adoptions and the projected impact on the criminal justice system. So there is excess powers given in the hands of police. I'm pretty sure a lot of participants have emphasized on it. Prosecution side is given more powers in trial, which may basically violate the rights of the accused. Accountability and efficiency are in conflict with one another. In the name of speedy justice and speedy process, is accountability really taken into consideration? Infrastructure of the system again is a big question. And overlapping and confusions are created because we have basically brought in organized crimes and many other crimes, but there are already state legislations existing defining the same things. So while deciding the matter, there's a confusion between this and the state legislation. So yeah, and then missed chance for gender neutrality, which could have been, a little better. Thank you.
A very warm good afternoon to all the dignitaries that all of you are presenting here. I am Nasma here going to present my presentation, and my topic is changing the attention of criminal jurisprudence in reference of human rights. In my present paper, I will be dealing with all the new and old laws and how they are being implemented. So without wasting time, I am just coming to my important question is what is the problem with our existing law? As one of my paper presenter already said, all the laws were made by the Britishers and now whether they are good or bad is another question. First of all the objective of making those laws to exfoliate the research of India and to stop any type of revolt from happening. Along with this, in the parliament, our Honorable Home Minister Amit Shah says that in this law, there are still more than 400 places where the British crown is mentioned, which even after 75 years of independence show the colonial state. Along with this, there are other problems in the existing criminal laws, like they are not in gender neutral, they are complicated in nature, etc. All these problems have been addressed in new laws. Now the important part of the topic is where we will find that what is new in this new laws. So to replace Indian Penal Code, Bharatiya Nyaya Sanhita has been proposed. In old act there were total 576 sections which were now only 356 in the new act. It has been discussed to modify around 175 sections, 8 new provisions will be added and 22 sections has been told to be removed, which will be added in new bill in some other way. If we will compare IPC and new bill, then we will find some provision which has been removed and these are very important laws. Like section 124 of SEDI, section 124 of sedition, section 309 attempt to commit suicide, gang rape for the woman and section 497 already like important provision. After that, I also list some provisions which are not in the IPC which are newly added in this new bill. In this new bill, new crimes of new era have been codified, like false promise to marry, section 69 of BNS, gang rape of women under the age of 18, mob lynching, organized crime, offense of a terrorist act, and like crimes. After this, instead of Code of Criminal Procedure, the Bharatiya Nagrik Suraksha Sanhita has been proposed. Before, there were 484 sections which have now become 533 and in new bill. 9 new provisions have been added here and there are 10 such sections which have been removed. The Act now has 167 sections and the new bill has 170 sections. These 5 sections have been removed from the Evidence Act and new
and new ninth section has been added. Now the judgment time, that what is good and what is bad. Let's start with good. The first important question is that did this new law become gender neutral? Because the major criticism of the old law was that we are not gender neutral. The answer to this is yes. So, if from the angle of victim and also perpetrators, the new laws are gender neutral from the perpetrator angle. For example, outraging the modesty of a woman, according to the Act, this crime could only be committed by men. You cannot file a case against a woman, but according to the new Act, this crime can be committed by both men and women. You can file a case against both of them. So, yes, it is gender neutral from the view of perpetrator angle. Secondly, the system of giving unnecessary adjournment for hearing is tried to be ended. The government has to say that with this new change, they want to make the legal system more efficient and productive. So if anyone files a case, equitable justice will be delivered within 3 years. Along with this, the maximum time limit of filing charge sheet has been set to 180 days, so that the trial process can start and unnecessary delay can be avoided. After this, new crime of the new generation like snatching, mob lynching, fake promise to marry, question paper leak, time, ATM theft, Ponzi scheme, all of these crimes have been recognized strictly. Along with this, terrorist activity, separatism, armed rebellion against the government by which can threaten Indian security and sovereignty, these acts have been recognized separately. In the previous act, they were denigrated in a particular section. The small crime, petty offense like drunkenness, stealing less than rupees 5,000. For these offences, for the first time, community service has been introduced as a punishment. Then a very controversial law, sedition, has been replaced. But this is just like a statement only, because the similar new section has been introduced in the new bill. So let's see the major criticism and follow this new bill. So the biggest criticism is about the names only. People has to criticize as this is a kind of Hindi imposition where imposition where the names are in Sanskrit and the content it is in are in English. So there is no Hindi imposition happening. Then the question arises that why couldn't we continue with the existing names? So the answer is that the existing law focus on punishment, as sir already said, like Bharatiya Dand Sanhita. Dand means punishment, but Bharatiya Nyay Sanhita, Nyay means justice. Secondly, Bharatiya Nagrik Suraksha Sanhita. Can we proceed, sir? Secondly, Bharatiya Suraksha Sanhita. Suraksha means security. So they focuses on justice only. And the next question that comes after this, that existing law, couldn't they have been amended or modified appropriately? What is necessary to bring a new laws? The answer is we cannot change the principle with the amendment or modification. For example, if a cloth is torn from place to place, how many times you will refill it? Likewise, the focusing point is the existing law had a lot of colonial reference. Along with this, the whole structure is very scattered. Where the new laws are good in structure, they have lots of good provision like digitization and forensic team. A strict timeline have been given for charge sheet, video recording should be done while recording the statement. So now I'm going to conclude my presentation, but before concluding, I'm having some question like whether India's infrastructure is this strong in relating to implement these laws, because all the schools and college will be have to change their syllabus and all the procedure of code will be changed and all the lawyers like have to reread all the section. So as you all know, government have announced that the new criminal law will be coming into force from 1st July. Thank you.
We lost the paper presenter P60.
Good afternoon to one and all. The paper that I am going to present, or the topic on which the paper is addressed upon, is the unaddressed technological concerns with regards to the new criminal laws and the impression on India's criminal justice system. Now, in regards to judiciary, the issue is not whether a judge is tech savvy or not. To be a judge in this country, one must be tech friendly or else ensure adequate training to familiarize oneself with technology. These were the words of Honorable Justice D.Y. Chandrachud, who was the 50th Chief, who is 50th Chief Justice of India. And technology has continued to manifest as the central issue in criminal law, given the modern world's advanced technological progression. New science, new understandings of the brain and its workings have brought new issues in definition of crime and law, as we have already seen by and presented by our dignitaries in the morning session. Also, criminal laws may target the mental capacity of the defendants or what they comprehend or were aware of when carrying out the criminality. So, the purpose of this paper is to discuss the regulated technological issues which emerge with this newly added criminal law and which affect the criminal justice system of India. So, without going into the overview of the new criminal laws, as the dignitaries have already been and my fellow presenters have already discussed in detail, I'll directly go into the subject, the main matter of this paper, which is technological concerns in criminal justice. So, digital evidence management. And many investigations and prosecution process nowadays use digital evidence as an essential component. As we know, there is one of the sections in PNS has added that compulsory requirement of videography during investigations. And it also covers data from computers, mobiles, cloud storage. Again, there is a section in the new Evidence Act, which under Section 2, Clause 1, Clause D, which includes all these electronic documents, which is well and good. Although the problem exists, or the lack of solution exists here, is that it is included what is required, which is electronic documents. Although it is not included how it has to be handled. So that is one thing that is the new laws are lacking in. So digital evidence management entails handling electronic data in a way that they stay reliable, recoverable, and acceptable in court of law. So collection and preservation is one of the main challenges that we have to overcome. Again, the same thing can come to cybercrime legislation. Now there are new laws that have been the new laws that have been implemented here have taken into consideration the cybercrime legislation. We have IT Act 2000. We also have a new law that came earlier in September 2023, which was Indian Data Protection Act. Although they still lack as to the procedure how these cyber crimes have taken place and how they have to handle the evidence with regards to these. And same can be said to technological training in the ground level or any level for that matter in judiciary or investigation. Enough technological training has to be given in order for these digital evidence to be handled properly. And also there is the issue of privacy issue and data protection. There is an interesting case study that I will refer to in later stage of this paper. And there is also infrastructure and expertise. Now we can see that there are live streams, there are videos of the judges, and pronouncement has been given on the internet, and there has been various sites which give us the judgment that is available for public. But again, these are not enough. We need more of them. Then, what are the specific issues? So when it comes to digital evidence handling, the specific issue is the absence of standard procedures in handling digital evidence and keeping it secure for use in court. For example, if we take the simple differentiation between a hard disk and a SSD. So many people don't know the difference between SSD and hard disk, and there is a big difference in handling them as well. When it comes to SSD, it is a newer form of form of storing data, but it can be handled in any way as we handle our USB or SD card. But the same cannot be said for a hard drive, as it has a very fragile component inside it, and if you handle it without any care, then the evidence might be destroyed. Same can be said for cybercrime provisions. There is a lack of comprehensive detection of new and growing threats. So when it comes to cybercrimes, we have to wait and see which type of threat has been emerging in the society. Unless we have enough data and serological data, or we have enough examples to see what type of threat it is, we cannot for sure make a cure of it. So it is also an area where we have to go for prevention is better than cure. That kind of perspective is required. Then in privacy and data protection, there is a lack of protection of measures of users' information. As earlier one of our dignitaries said a story about how he caught a robber and his false alibi, right? He went through his phone, he said that he can access his Gmail and he can see the timeline that he has went through. He can take all that information and see whether that person is lying or where he has been. But that same manner, there are no guidelines for such things. Right? It is a procedure that he on his own has taken. Now, what he did is correct for the time. But again, to support him, there are no guidelines. There are no laws. There are no set of rules that says that you can do this, but it has to be done in such manner. And coming to the case studies, which can be in this scenario, one of the main case studies is Arjun Pandit Rao Kutla versus Kailash, where the court stated that electronic evidence has to be available at the trial and that the certificate can be produced at any time before the trial. So the validation is also a problem when it comes to the digital evidence. There is no as such notary, there is no as such attestation when it comes to electronic evidence. The electronic evidence has to come, an expert has to come to validate it, and then again objection will be put. So there is a delay in justice. So instead, if there is an authority which before the trial itself can certify that this is a genuine set of records in the electronic form, then it will be very useful for the judiciary. Then another case study would be Arushi Talwar murder case. In this very problematic situation where there was shortcoming in the initial investigation. The police didn't go through any of the online sources of or any sorts of accesses. But the CBI had to enter, and then they went to all the messages, and to which they got a clue to which such crime has been connected around. So my recommendations for this would be comprehensive digital evidence protocols. In America and Australia, they have guidelines as to how these investigations are concerned, and they have complete guidelines which the police officers or the whole judiciary has to follow. Then cybercrime legislation updates, then privacy and data protection laws, specialized training programs for law enforcement and judiciary, technological infrastructure, establishment of cybercrime units, and forensics. So in conclusion, the use of technology and in the criminal justice system is now an imperative as well as a problem in the world where almost everything is controlled by the use of technology. So despite the recent legislation reforms we have been achieved in India, being comprehensive and proactively designed, those reforms lack the presence of significant technological considerations. Thank you.
Thank you. With this, we have come to the end of the paper presentation. Now it is time to hear from chairperson. Now I request Professor Dr. C.S. Patil sir to sum up the technical system. Over to you, sir. Sir, final remarks.
For what if you once I was deprived of listening to presentations by the students because, as you know, I am a retired professor. It was really so nice sitting here, listening to all of you make your presentations. We are all conscious of the fact that it is a time constraint. 5 minutes is not the time to present whatever you have researched study, analyze. At the outset, I compliment all of you for the exercise you have undertaken. We have marked your performance using some criteria. Language, content is for 30 marks, language is for 10 marks, presentation is for 10 marks. It is the substance that matters, not the package. Okay? All of you have done well, there is no confusion about it. At your age, I was not in a position to do this. Okay? Let there be some clarity. Right? Now you have started writing. Writing, we always say, when we train our doctoral students, the real test of writing is in rewriting. Madam Nirmala is sitting here. My guide made me rewrite one chapter 5 times. That was not for PhD, LLM, dissertation. Rewrite and rewrite. And in law, what happens is, the equation is, it is 80% analysis, 20% writing. Any legal exercise. Okay? You have to apply your mind. Thinking is a difficult exercise. Because thinking is a difficult exercise, we judge. ಅದರಲ್ಲಿ ಅವನೇನು ಮಾಡಿದ ಇದು ಚೆನ್ನಾಗಿರಲಿಲ್ಲ. You can pass remarks like that. You can pass remarks, you are passing that remark because you are not in a position to apply your. You have to take help from your teachers when you venture into activity like this. And it should be, one thing I tell you, how many of you have checked the meaning of Constitution? Heart and soul, tell me, did you check the dictionary meaning of Constitution? You are last students, you have come to study Constitution. Right? It will give you what Constitution is. And I tell you, this is the stupidity that we see. Criminal law, we are speaking about criminal law, no? A student kill a person. What is the actus reus here? Come on. A student kill a person, what is the actus reus here?
Shooting.
No. That is the actus reus. This happens because none of you have read the original prescribed book. Okay? How I know you do not know all these things? Arey, beta, I have completed 30 years in that. I know you will never open the meaning of Constitution. You will never refer to a dictionary. This is not the way law is to be studied. Law is to be, see, first lesson I give to my children in my school was, we come across this dialogue. What you mean? The reply of my students will be, I mean what I say. I am a lawyer, I know each word, everything is there. If I have spoken something, I mean it. Simple. And when you write a paragraph, the person who reads that paragraph should understand that this is a lawman who has written this. I have total command and control on that language. This comes by practice. And what happens is, when you write these things, you have time, you pause, you reflect, you arrange so many things, then bring a paragraph from here, then go back, redo. All this exercise happens when you write. Writing is a very, very great exercise. Keep it up. Continue this. Write for journals, write for magazines. Otherwise, create your own blog. If nobody is publishing, you publish. Anyway, you are all good in this social media and all those things. Have your own. See, you will not believe if you Google. I have YouTube channel. Why not? And the latest one, who is this girl who came with MacBook here? You have iMovies in that? You edit movies there? I do it. Okay. I want to learn. And my tab is pro. I was telling Nirmala madam by the side what I do. Why you kept all these things open here? This is a different version. It happens different that. And you have Microsoft installed in that? I have not done that. When I paid 1 lakh rupees for this, I will use that software only. Why I should pay another 10,000 rupees and install Microsoft? I will use it. Whenever I do it, why take this? Return on facility. Engine on the Apple. ಗೊತ್ತಾಗ್ಬಾರ್ದು ಕವರ್ ಆಗಿಟ್ಟಿಲ್ಲ ನಾನೇನು ತಗೊಂಡು ಬಂದಿದ್ದೀನಿ ಕಂಟಿನ್ಯೂ ದಿಸ್ exercise. And there is lot of confusion and commotion. I am learning. I told you, in the morning, I am reading this book. You must know your constitution, I am reading. Judging democracy, I am reading. I keep on reading. There is no way, otherwise I will become totally irrelevant. Professor Venugopal keeps on reading and writing. But none the other ಕೆಲಸ very old, very addictive. You have done a good exercise. At this stage, you deserve all compliments and congratulations. Somebody will get some praise because some criteria for elimination. That is not important. You see, I sometimes sing, not for competition. I sing the way I like, I enjoy, I celebrate. I dance for my happiness. No, not in the competition. Wherever it is privilege, I should enjoy my dance. What about you? It will be up to you. If you also want to enjoy my dance, enjoy. Otherwise, I am going to. Whatever that is to be celebrated is to be celebrated. Whatever that is. Now these cricket people are there, no? They are not playing any game. Cricket is not a playing of game. That is something different. It is, you can say whether it is farmers or whether it is something is happening there. But when you play the same cricket, you celebrate. No, you will enjoy. Goal out there, catch out there, you will be happy. ಯಾವ ಓಡುವ ಜಾಯದಿಂದ ಎಲ್ಲ ಖುಷಿ ಆಗ್ತಾರೆ hero is not hero, he is an entertainer. Right? So he is doing the job, I am doing my job, you do this well. 5 years, 3 years, whatever, wherever you are, from here you start. And when you are involved in writing, analytical skills develop. Brain needs to be trained. There are two ways. One is genetic lottery. You are born with that combination of genes where you are endowed with powerful analytical skills. You are a best. But if you are not endowed with that genetic lottery, then what you do? You have to train yourself. It is possible. Anybody can train himself in analytical skills. It only comes by practice, like artificial intelligence. What is artificial intelligence? It is a very same platform. For about 5 years back, the Vice Chancellor of Manipal University was here. They have taken the services of artificial intelligence in curing cancer. Manipal. The success rate is 99.99%. No doctor can match the line of treatment, this artificial intelligence, whatever scan is this, you give it to that will, whether it can be set right, whether there can be an operation, or whether it should be symptomatic treatment, whatever, it will never fail because so many reports are fed and it has become intelligent. After using all that, it works round the clock. No rest. Any development anywhere on earth, it will become. That's how it works. Artificial intelligence. In law, Google right now, all of you, Ross, artificial lawyer, ROSS. This is in service for more than 15 years. Okay? And you are modern law students. Smart settle, blind bit, pre-solve. Okay? Smart draft. Very different things have come into existence. And we should keep ourselves updated. And we should also think in terms of how we are going to be relevant. How we are going to be relevant with all these inventions, with all these things being present. That's all. And one last thing I want to tell you. One last thing. That is conceptual clarity. Okay? I told you. You have ventured into a conference on new criminal law without knowing what is actus reus. I stopped there. If I ask further questions, all of you will become very intelligent, not artificial, natural. These things happen. These things happen because we are not learning things properly. Be thorough with fundamentals. This is most important. Be thorough with fundamentals. And if you are thorough with fundamentals, you can captivate, you can conquer the latest developments anywhere in it. And if you are not thorough with it, if you do not know what is property, there is no question of you understanding intellectual property. First understand what is property. Contract, where from contract has come into existence. Learn it. Human rights, what they mean. Understand what is human rights. Okay? If some of you want to be in touch with me, there are so many children who are in touch with me, and my weakness is children. I like children of different talents. If you want to discuss anything, if I know anything about that, you can talk to me. And my phone number is readily available somewhere on the internet. People keep we got your number from Google. I don't know where from. I also searched if I can get my number, I did that. Okay, all the best, you have done a good exercise. Continue this. Continue this. You will reach your ultimate mark. This is a very difficult task to write. You have started, maybe by the time you complete your degrees, your names should appear in different law journals, including VBCL, law journal, and any other law journal. All the best, congratulations. Thank you very much.
A very good evening to all the esteemed guests, distinguished resource persons, and all the participants around the nation for the one-day national seminar organized by Karnataka Institute for Law and Parliamentary Reform, Bengaluru, and Vaikunta Balika College of Law, Udupi. We have had an enriching day full of insightful presentations and discussions, and it is now time to conclude with the valedictory ceremony. As a token of appreciation and respect, we have curated mementos for our esteemed dignitaries. I kindly request our principal sir to present the memento to Dr. Devaya Odell. Thank you, sir. Now I kindly request Dr. Srinivas sir to present the memento to Professor Dr. C.S. Patil sir. Thank you, sir. Now we have come to one of the most awaited moments, the prize distribution for the best paper presenter. May I kindly request Professor Dr. C.S. Patil sir to come forward and hand over the prize Thank you, sir. May I kindly request Dr. Venugopal DS sir to come forward and hand over the prize. To second prize, Ms. Chandralekha KM, KLE Bangalore. Thank you, sir. Now I request Nirmala ma'am to hand over the prize. Third prize, Miss Sanjana S. VBCL. Both the prize winners, please come on to the stage. All the participants, please collect the certificates from the registration counter and prize winners kindly meet Dr. Jayammohan madam.
Prizes are only three. If I were to be the principal of this college, I would have distributed state. All of them deserve a prize.
Before we conclude, I would like to quote by Martin Luther King Jr. Injustice is a threat to justice everywhere. I unquote. Over the course of this seminar, we have explored numerous facts of our new criminal laws. From insightful keynote addresses to paper presentations, we have dissected the impacts, challenges, and future directions of these laws. Let us carry forward the knowledge gained here and strive to uphold justice in our all endeavors. I would like to thank Professor Dr. C.S. Patel sir, Dr. Revaya Odeya sir, and Dr. Venugopal sir for striving hard for the success of this event. Thank you, sir. I would also like to thank the seminar coordinator, Dr. Jayamul madam, the participants, students, council members, and all those who have worked hard for making this a successful event. Thank you, one and all.
Participants, please come forward for
ಈ ಮಾಡಿದ್ವಿ